Hey, folks, welcome to the... I, I forgot to do something. Hold on. Yeah, I forgot that on my laptop over there I was preparing, and then I forgot to turn it off. Yeah, okay, let's start over. Hello. Today, Thursday, April 4th, I expect Fani Willis in court because she is the one who wrote the reply to Mr. Steele's motion to disqualify. So I expect her to show up today. And I also expect fireworks because her motion or reply, I read parts of it in the stream yesterday evening. It's not good. So I expect fireworks. But until judge shows up and everything starts, we are going through Tuesday and Wednesday because there were interesting stuff going on. So Tuesday, Wednesday, Thursday in this stream. Welcome to the show. Yeah, so let's start with, well, just to mention, I have everything checked out on another tab, so I will see when today actually starts. But until then, Tuesday, hearing day, it says 6.5 hours. Well, not really. A lot of breaks, a lot of pauses, maybe hour and a half, 2 hours tops. So we will get through that. And we will break for today's because today is completely separate, and then we will go back and go through Tuesday and Wednesday again. Okay, let's see how it all started out. Let me know if sound is okay.
Hi, good morning, council's interested parties. We are back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Let's see, Mr. Stillwell, Mr. Sharp, good morning. All right, Mr. Williams, Mr. Steele, Mr. Adamson. Okay, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Ewing, Mr. Matthews, Senior, good morning. All right, Mr. Nichols, Ms. Westmoreland, and tis you. Okay, all right. Good morning, madam. And
Just
Mr.
because
Ryan
the
and
judge
Mr. Williams, good morning.
sounds is okay,
All right.
doesn't mean the
Mr. Housekeeper,
prosecutor
Mr.
can
Atkins, and Ms.
find the
Love, good
microphone.
morning.
Oh, start off with the roll call as per usual. And hello over at Twitters and hello over at Rumbles. Yes, I am streaming on Twitter and Rumble as well today. Sorry for you Rumblers that I've been bad at streaming on Rumble the last couple of weeks. Time management from my part. My apologies. I will try to get better at it. And silence. Come on, Josh.
All right.
I agree, Lucent Hill. I will be surprised if things
Okay,
goes
the
the way
first
they
thing I
should.
wanted to take up, councils, is Mr. Williams' motion to supplement, should say motion to supplement to motion limiting number 2, motion to strike in regards to the court's earlier rulings consistent with the lyrics and songs that I said that the court will preliminarily admit.
Yeah, this is songs, lyrics, and music videos. The Georgia Supreme Court have decided that these in general are not admissible unless the prosecution can show a direct link. And that doesn't mean, oh, put a cap, blah, 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 and they accuse him of murder. No, it has to be descriptive of the actual and good description. So the Georgia Supreme Court, that decision is amazing. I mean, it really narrows down the amount of times the prosecution can use lyrics to very few selective. And so that is the first hearing. I know what happened, but maybe a few of you don't, so I will not spoil anything. I will try. I can't guarantee, but I will try.
Subject to a foundation. Since that ruling, there has been a case by the name of Baker, and it is case number S20.
Patrik Hedbom, god eftermiddag från Dalarna. That is in English. Patrick, 50 Swedish krona. Good afternoon from Dalarna. That is a region in Sweden where my dad grew up. He grew up in Ludvika back in the 40s and 50s. So, yeah. Welcome, Patrick.
23 Alpha 0860
thank you for the super
decided
chat.
5 March of 2024 concerning issues that may bear upon the court's ruling. Mr. Steele and who's ever arguing for the state, I'm willing to give you 30 minutes apiece because I've read Baker, and of course I've already made a ruling. So it doesn't really require me to get spun up or educated that much on it. So consistent with that,
Oh,
I'll
really,
start out,
Judge?
Mr. Steele, since
Really?
it's your motion, go right ahead.
You don't need to be educated. Yeah, let's just see. Let's just see. Oh, by the way, I started a stream with the first part of the Georgia Supreme Court ruling. It is from a couple of weeks ago. And I said then, oh, I will return with the rest of it. I haven't yet because I got a cold and I don't have time. I will say, if I get the time tomorrow, Friday, I will go through the Georgia Supreme Court ruling on lyrics and music videos as evidence in trials. The judge said Baker, as in Broken Baker. Yeah, sure. Broken Baker was an item in the Georgia Supreme Court.
You may.
Remember to hit that thumbs up, by the way.
Now it is. Thank you. Okay, Your Honor, thank you so much and good morning. Honorable Court, good morning to everyone. I did file what the court has already announced, and I appreciate the court's time to consider the Baker case. In the Baker case, Your Honor, I know you've read it, heard what you just said. I focus then on the fact that Baker was not a gang case, not a RICO case, not a conspiracy case, a RICO conspiracy case. I understand that, but it did involve the playing of just a video. what was deemed by the Supreme Court of Georgia a rap video, no lyrics, because the lyrics were not understandable. But the reason that I found it important to raise on behalf of Mr. Williams, our supplement to the motion, in limine number 2 motion to strike, filed on the 6th day of March 2024, the day after Baker was decided, was that the highest court, and it's a 7-2 opinion in Baker, really took to task the use of a video, just the images. The video was, and I'm quoting from Baker, the video was glorifying violence and gun violence and a sort of street life, glamorizing it. And then I go to footnote 16, and I've given the Honorable District Attorney already a copy, and I've given this Honorable Court and the Honorable Mr. Kearns a copy of the 3 cases that are in footnote 16, where the Supreme Court of Georgia wrote, we note that the probative value of the rap music video was further diminished by the state's failure to present any evidence that Baker's performance of Crawford's rap song was not wholly theatric. And then they cite the United States versus Gamory, Gamory, which I'll get to, Your Honor. And they write, explaining that a rap music, they being the Supreme Court of Georgia, explaining that a rap video was minimally probative under Federal Rule 403 because there was no proof that the appellant authored the lyrics or that the views and values reflected in the video were in fact adopted or shared by the appellant. So I thought that was important because here the state is trying to introduce numerous lyrics and videos.
Let's talk about that. Baker arguably involves the introduction of a video, which there's little nexus to what they're trying to prove. Could you discuss for me how that, in this particular case, the state has said, look, we're gonna tie this to some aspect of membership, of leadership, and other things that are required to be proven under the gang statute. So tell me how, if you could distinguish that for me or talk about that, because I think the facts in Baker are a little bit different than the facts in this particular case. And remember, I've also told you it's subject to foundation. So so address that for me if you wouldn't mind.
Sure. So I don't believe that the state will show any type of nexus. And in New Jersey versus Skinner, SKINNER, which is 95A as in Atlantic 3D 236 2014, cited, the reason I'm using it is cited in that footnote 16, and in the copy of the copy that I gave this Honorable Court, the printed copy this morning, and the parties in page 11 of 15.
Are you talking about Skinner?
Yes, it should be on top, Your Honor. New Jersey versus Skinner. And on page 11 of 15, it's footnote 5, which is at the bottom right. And I think that answers.
So, Judge, oh, I read this, and so I don't need to be educated. Yeah, this thing that is cited in this footnote, let's talk about that. And the judge, whoopsie. Yeah, Judge, when the Supreme Court of Georgia or any state or the SCOTUS, you really need to not only read the decision, you need the footnotes and the citations. I didn't know. I had to tell Judge Glanville this, but apparently I did.
For me, the question, and that was cited by our highest court in Baker. And it specifically says in that footnote, of course, rap lyric evidence that provides direct proof against a defendant, such as an admission or details that are not generally known and dovetail with the facts of the case, should be analyzed for relevance under 401 and evaluated under 403 standard for prejudice, and not the standard for prejudice under a Cofield analysis. And then they cite another case from New Jersey, recognizing the intrinsic nature of evidence that directly proves charged offenses as excluded from 404B's analytic framework. A jury need not be shielded from a defendant's confession simply because it conveyed in a rap or other artistic setting. And what I'm saying here is, Your Honor, the state can't do that. When we had that last hearing, it went till late at night. The state was saying things like, and I'm just using out of the indictment, I ain't killed nobody, but I had something to do with that body. They just said, there it is, Judge. That's what we're saying. We're saying that Mr. Williams' hands are always clean and he has other people kill for him because he's the leader. That lyric, first of all, is used in other songs, which I've mentioned to court previously. But in addition to that, that's not something that's unknown. There's no details. There's no nexus. This honorable court, to admit that, is just admitting the artistic work, doesn't know if it points to any type of killing. It just goes to propensity. And I believe under Baker, 403 analysis should shield it. So I hope that answers your question, but that's what Skinner says to me from New Jersey. That was cited by our highest court. in Commonwealth of Massachusetts versus Gray, which is another case I've given this honorable court and the parties. And it's on page 12. Oh, I'm sorry. It's 978 New England or New Northeast 2D NE 2D 543 2012 on the opinion that I've given to this honorable court and the parties on page 12.
Up 13?
Yeah.
Yeah. What Mr. Steele is doing here is now he showed Georgia Supreme Court decision. Then in the footnote, the citation the Georgia Supreme Court used to come to their conclusion, which means in lawyer speak, yeah, you can go outside of Georgia to find basis for this. And this is what Mr. Steele is doing now. Going Baker, the citation, and now what else backs this up? Even because up until a month ago, a month and a half ago, Georgia apparently didn't have this First Amendment thing where free speech in lyrics stuff. It can be evidence, and it still can, but extremely narrowed down by the Georgia Supreme Court. Now, I assume that Judge Glanville is the type of judge that if he can find a loophole that is vaguely connected, he will use it.
Okay.
On the left-hand side, the first full paragraph, it's in the center of 12. The video, I'm just reading what the court wrote from New Jersey. The video was produced at an unknown point in or before 2005 and was available on a commercial website promoting rap artists. The defendant did not write or perform the lyrics or produce the video, and it was not found in his possession. The lyrics show no connection to the defendant that would suggest that they were, biographical or otherwise indicative of his own motive or intent at the time of the shooting. Yet the video was admitted specifically as an asserted statement of gang allegiance by the defendant based on Sheehan's, which is S-H-E-E-H-A-N, apostrophe S, voir dire testimony to its meaning. Even if the video had contained direct statements of the defendant's gang allegiance, we are not persuaded by the opinions of courts in other jurisdictions that view rap music lyrics not as art, but as ordinary speech, and have allowed their admission in evidence as literal statements of fact or intent without contextual information vital to a complete understanding of the evidence. And to answer your question, I hope I'm answering, but the state can't do that. They didn't proffer to you anything that would associate these lyrics with a certain crime. The closest they came is they told the court that trestle tree, that Jeffrey Williams said the word trestle tree, which is a section, a street where crimes were committed in this case. The fact that he is using trestle tree in a song certainly cannot be that he's somehow involved in that crime. In addition to that, the prosecution has spent 4 months.
Here's when this was argued last time, a few months ago, the state argued that since this is a RICO case, they only have to allege and then prove for evidence to be brought in. They don't really need foundation even, because they allege gang activity, they allege crime, they allege this, that. And here's the thing with the Georgia RICO Act. And I've said this before, and I'm sorry to tell you again, it is so broad and so vague that basically anything is allowed unless there are strict rules against it. If there is an exception, the judge can use it. And I think that is appalling, but that is the way this Georgia legislators want. They don't want this evidence thingy and foundation thingy. That's too much of a hassle. Screw due process, screw this. They don't care. Oh, they they were never even charged 10 years ago. We don't care. Let's take a second bite of the apple and call it RICO.
Showing or trying to show that Mr. Williams is the leader of this gang. They have put on over objection Mr. Bean's recorded statement with Detective Quinn saying that Jeffrey Williams orders, he commands Mr. Murphy to do something. They put on Trintavious Stevens, who said inconsistently, but said Jeffrey Williams is a member of the gang. They put on that Jeffrey Williams is the slime, the big slime, King Slime, rather, excuse me. They put on Detective Belknap. They are going to use, over objection, Detective Gaither as a gang expert on YSL. They're going to use Detective Dennis as a gang expert on YSL. Over objection, they're going to use Investigator Viverito as a gang expert on.
Yeah, they have 5 different gang experts. They all work in the same precinct, and they are all trained by the same person. Yeah, how the judge doesn't see that as cumulative, I don't understand. But here we are. And that is why Detective Belknap, I think it is, who the state uses as both a fact witness and an expert witness, blurring the lines between expert testimony and cop testimony.
YSL, and all of them make, for certain, over objection, Mr. Williams the head of this supposed criminal organization. So why do the lyrics have any probative value if it's simply cumulative? I'm trying to answer your question, but my point is to use the art, to assume that that is statements that the state argued are confessions. That's what they said. These are confessions. They said that we didn't go out and find them. Mr. Williams, handed them to us. These are his inner workings of his mind. But it's an artistic industry that our courts now, for the first time, this is the first time in Georgia, our court has said in footnote 16, we got to be careful. And they cite to these cases that say you got to be careful. The next case cited by our highest court is United States versus Gamory, G-A-M-O-R-Y, and that's 635 F3rd 480. It's 11th Circuit 2011. Again, it's in footnote 16 of the Baker case. And on the copy of the opinion I give in this honorable court and the parties, it's in Division B, as in Barry or Bravo, and that starts on page 7 of 11, Your Honor. And it's entitled The Rap Video. These are lyrics and video, just like the Gray case and just like the Skinner case, where lyrics and video. And I am targeting on page 7, the right-hand side in the center paragraph that starts with the following. Based upon our independent review, I'm sorry. Yeah.
And this is so disrespectful, in my opinion, from the judge. Mr. Steele is in the middle of his argument, and judge says, oh, I got a call. I don't care. Turn your fucking phone off, judge. Nothing is, you're the presiding judge over this. Turn your fucking phone off. If they really want to get a hold of you and it's really urgent, they can call your clerk who will notify you. But just interrupting Mr. Steele like this is so disrespectful. Imagine if the judge was in the middle of one of his lectures and somebody pulled out phone. Sorry, I got a phone call. Can you pause? He would get livid. But judge, I got a call. I got to take this. No, you don't. Unless it's, I don't know who called him or what, but whatever it is, unless it's somebody actually dying and you have to go to the hospital to say goodbye or perform the last rites, that's not important enough to break off a hearing. And this, I believe, is one of the reasons why this court is so late all the time, because the judge, when he's not prioritizing the prosecution, he's prioritizing something out of court. Yeah, and hit that like button, would you please? The thumbs up. I think I deserve it. I know I deserve it. And this is also why I said this 6.5 hours. Yeah.
Okay. 5 minutes back in, okay?
Whatever you say. Yes,
All
sir.
right, go right ahead, sir.
In United States versus Gamery, and it's on page 7 of 11, Your Honor, on the right-hand side under the rap video. Starting in the center, the 11th Circuit wrote, based upon our independent review of the rap video and the totality of the record, we conclude that it was error under 403, Federal Rule of Evidence 403, to play this rap video to the jury. We recognize that the video could be construed to discuss Gamery in as much as the lyrics refer to JB, a white crib, a Range Rover, drugs, and hush money. And because the artist in the video, Tone Flora, F-L-O-W-A, wore a necklace with a JB insignia and was similar to cufflinks seized during the search of Gamery's residence. But the substance of the rap video was heavily prejudicial. The lyrics presented a substantial danger of unfair prejudice because they contained violence, profanity, sex, promiscuity, misogyny, and could reasonably be understood as promoting a violent and unlawful lifestyle. At the same time, the video was not clearly probative of Gamery's guilt. We cannot ignore the simple fact that Gamery was not in the video. Neither was there any evidence that Gamery authored the lyrics or that the views and values reflected in the video were, in fact, adopted or shared by Gamery. We're also mindful of the fact that the government introduced a rap video at the end of its case after it had already presented significant evidence that Gamery was JB and he owned Hush Money Entertainment. These facts are not seriously contested at the time the video was introduced, and such evidence was therefore cumulative. In short, the probative value of the rap video was minimal at best. More importantly, substantially outweighed by the video's unfair prejudice. We have already said that Mr. Williams owns YSL. He is an entertainer. He goes by the performer's name, Young Thug. He associates with people that are unfortunately indicted. Some of them pled guilty, like Mr. Kendrick. They have done music together. Mr. Arnold, they've done music together. He pled. Mr. Kitchens, they've done music together. He has pled. The state just doesn't need it, and they don't have that connection. And again, going back to footnote 16 of Baker, Your Honor, the court wrote when discussing State versus Skinner, the difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because the author has chosen to write about certain topics, he or she acted in accordance with those views. And all I believe is going to happen is you play those videos with those lyrics where you have somebody say, here are the lyrics taken out of context, then the jurors will be horrified and be prejudiced, as was in Baker. That is pretty much my argument. I'm not changing anything I relied on. I heard what this honorable court said, and I did understand you to say that the state has to lay a proper foundation before they can admit any of these. But that foundation now, according to Baker, is really tied hard to specific facts and not just generalities. That is my argument.
Okay, all right. Thank you, sir.
Thank you, Your Honor.
All right.
Okay.
Mr. Shard, I'll give you the opportunity to make your argument now, or you can wait till I finish with, because you've got some similar probably argument, so.
I didn't hear it last.
I said you've got some similar argument, that's what I was.
I heard you say I can make it now.
Yeah.
Okay.
Yeah.
Would you like me to make it now?
Yes.
Okay. So, Your Honor, just for clarification,
I'm going to fill up my coffee.
motions
Be right
regarding
back.
two
I will
different
still be listening in.
pieces of
Yeah, you have a
potential.
motion to,
One is a song.
yeah, one is a similar to what Mr. Steele filed in terms of Baker. And then the other one was a motion limiting to strike regarding song lyrics.
Right. I mean, both, Baker touches upon both.
Okay,
In Your Honor, what I'd like to do is, just so we're all clear, these last less than a minute, if I could just publish them to Your Honor so we can see exactly what we're talking about. Mr. Weinstein, if you'd help me out. Either one is fine first.
Still waiting for today's court. And so half
Yes.
an hour late so far.
Unmuted it.
Okay, I have to mute this because if I don't, they will. I will get copyright struck. So sadly, I have to go.
And that will be the verse from the song that in my motion, I titled Smile It Off.
Smile it off?
Yes.
Okay.
And
all
then
right.
this is a social media post that was provided in Discovery.
All right.
Yes.
And this is the second one?
Yeah, I know another CD. I know it's fair use, but the 2 times I played music or videos on my streams, I got copyright claimed. I asked for a review, and then they just waited out all the 30 days, and then it was gone. Here's the thing. When I do that, I get 0 ad revenue or anything. So, yeah. And after 30 days, then no, I mean, nobody watches a month-old streams of this trial. Maybe a handful have seen those streams since then. So it's just not worth it. And so yeah, I don't know why the music label is copyright claiming, since I'm covering the trial of somebody I believe is wrongfully accused, but here we are.
Yes.
That same shit that got big.
Is that still well too?
I don't think that was the entirety.
Just play it again.
All right.
So that's still well too?
That is still well too.
Okay. All right. What's that called? Was that just a social media post?
It was social media post on Baller Report. I believe we could call it.
What date?
It doesn't, to my knowledge, it doesn't have an exact date.
On or about?
In the Discovery, I don't believe it had a
On or
date.
about? You have an on or about date?
I don't. I mean, I could speculate, but just by how old my client looks, but I believe it's probably from 2015, but I don't know that for an absolute fact.
All right. So it's a social media post?
It is.
Okay. All right. So I'll consider Stillwell's 1 and 2 for purpose of motion.
Okay. Thank you, Your Honor. All right. So obviously, I'm objecting to the admission of both of these videos, and I think the analysis is similar for both. First, I think we need to ask what the state's theory of admission is. And the first question that you asked Attorney Steele about his issue, I think is important to ask in this case. What is the direct nexus? What nexus is there to any allegations in this indictment, any crimes? Regarding the video Smile It Off, I will concede it is listed as an overt act, 95, okay? And I'll get back to that. My stance is just because the state pleads something as an overt act doesn't make it automatically admissible. If I had a client who said something in a confession that was deemed inadmissible for Miranda violations by the court, and the state decided to put it in their indictment as an overt act, it wouldn't overrule the gatekeeping function of the court to keep it out. So,
Good argument.
so that is listed as an overt act, but it has no ties and no nexus to any substantive offenses. Essentially, in that rap video or in that verse, I believe that you.
Yeah, seriously, there are over 200, close to 250 people here watching. 150 likes at least. Folks, you can do this. It's just check the window under there. There's a thumbs up and you press it. It takes you, you can do it while watching and listening. Thank you.
Can see my client. Now, I know the state has pointed out in previous pleadings, he is allegedly wearing a YSL necklace and he's
Good
allegedly
morning.
wearing red. What does he say? He says,
I
he
like you
talks
too,
about
Peace Peony.
going to, I believe he says the plug, but essentially robbing drug dealers or drug distributors. He boasts of keeping a stick, which common parlance is an assault rifle, on him. and he says, I just beat a murder rap, paid my.
Okay, I see that today's court have started, but he isn't talking yet. So we will listen to Mr. Shard first, listen to him, and then we will go over to today's motions hearing.
Lawyer 30 for that. Now, none of those statements, robbing drug distributors, that has no direct nexus to any substantive charges in this case. Keeping a stick has no direct reference to any charges in this case. I just beat a murder rap, pay my lawyer 30 for that. Now, I think it's fair to say that that is most likely a reference to being wrongfully arrested back in 2015 for the murder of Donovan Thomas. He was arrested in October of 2015. He stayed in jail for a long time as his co-defendants' cases had their preliminary hearings, were dismissed. Eventually, the state dismissed cases against all three other individuals that were charged in that case, along with Mr. Stillwell. Mr. Stillwell was granted bond. And as artists do in their expression in hip hop, it may have been a certain level of fictionalization because we know, in fact, it was not dismissed. He was, in fact, on bond. But that is not in any way an admission of guilt. That is just a statement that I was wrongfully arrested in the past. I paid my lawyer for that. I have no idea how much he paid the lawyer. It wasn't me at the time. But, you know, that's just an expression of artistic freedom. And also, but even if it is based in some facts from his past, it's not an admission to anything. It's completely irrelevant. It's just saying I've been arrested and I beat the case. And it becomes harmful with the next line where he says, me and my slime's above the law. It becomes the idea of bragging, of boasting. That's where the prejudice comes in. To the jurors, oh, you think you're above the law because you're rapping about being wrongfully arrested. Now you're free. And now we get to judge you for that. It's very prejudicial. So we have trying to rob them, drug dealers, keeping a stick, and I'm above the law. Okay. No evidentiary value to any substantive charges in this case. Not admission, it's not intrinsic, it's not 404B, even though we were never given notice of it being 404B. It's just wholly irrelevant to this case, except for maybe I concede the slight relevance, the scant probative value of wearing a YSL chain. I'm not even going to concede wearing red has any probative value to anything, but wearing the YSL chain. And we'll get to the balancing test later on. Regarding the video from where we're saying possibly 2015 in the car, Mr. Stillwell on that is calling out.
Mr. Sharp, before you move on, let me ask you a question.
Yes.
You don't believe that your client's statement potentially of I beat a murder rap might be an admission?
He was, it's not in dispute. He was arrested.
No, he beat I mean, that's just they dismissed it eventually.
For murder. Okay. I mean, that's known. We're going to talk about it. He was wrongfully arrested for murder in October of 2015.
Isn't that one of the predicate acts that the state is alleged in?
It is, but I don't see how acknowledging.
If that, as you say, Judge, is an admission, how come he wasn't convicted? Judge, the case was dismissed at the time. So if the prosecutor at the time said, no, F it, can't prove it, can you really claim admission of guilt now when it's already been handled?
That you were arrested for the murder and either released or.
But you're saying about it though, and in that for the jury to. I mean that's directly probably one of the more stronger things that that the courts heard in terms of just.
So if
involvement because they can look at it for several reasons, for a couple of reasons. One, he's membership, and the fact he's wearing a YSL chain.
Okay,
two, that he's wearing red, and three, that he's rapping about a potential issue that he's been involved in.
Why are you arguing the state's case, Your Honor? Again, this is a motion where the state has to argue against it, and you decide on what they present. Instead, you are there acting as a prosecutor against the defense motion.
Well, I mean, two, and if it's alleged as part of one of the overt acts. Of course, the state's got to lay a foundation as to that, but
And I'm going to go into 1 and 2, and I'm not going to push back on that, Judge, the chain and if wearing red, but the referencing, I mean, if I write a book, if I'm arrested for murder and I write a book, talk about, well, I was arrested for murder and, you know, this was what it was like for me in Rice Street. And this is, and I beat the case. And then the state, and I don't say anything about the allegations, nothing about guns, nothing about motives, nothing about anything. And then the state charges him with murder 10 years later. I wouldn't see the relevance of me in a book saying, oh, I was arrested for this. We all know he was arrested. He was arrested for murder. He was charged with murder. That's a known fact. I don't know why we need this song to be admitted to show that he was.
Was there a trial on the murder?
No, this is the trial.
Okay, all right. So basically, your client's alleged participation in this or commission of this murder is fairly contained with this indictment, correct?
Correct.
Okay, so why wouldn't that be considered potentially a statement against interest or?
Because it's not against interest. He's just stating a fact. He was charged with murder.
Okay.
I mean, that's not against interest.
I know, but you have a choice as to whether or not you want to say anything, or, you know, one of the views of our Constitution is, hey, you can, I mean, a couple things. You certainly have a freedom of speech, but certainly you have, you know, advice of counsel, and certainly you have the issues of whether or not, you know, whether or not you make statements that are against your interests. And especially if you put them in a song, I mean, relative to.
Okay, they are going on for a good while, and they have actually started over at today's hearing, which is, so we will get back to this part, but the motion to disqualify, that's interesting. Hold on, share, big screen, there.
Reportedly, that Miss Love may have had with the witness, where it's just the two of them. So when you're dealing with that, that's kind of what I kind of want to focus upon in terms of the court's inquiry. So if that helps you in any way, okay?
You always help, Your Honor.
All right.
Thank you. Let me just, can I just approach and move the court in cases that talk about that?
Sure.
I've already done it, so approach.
Sure.
Good morning, Your Honor. Good morning, everybody. And so, Your Honor, I will get to when Ms. Love was not with someone else. But I have two issues that I'd like you to include in that to make this seamless argument. And if Mr. Kokomo, when he's available with the court's permission, can just play two small clips from our court proceeding. I understand it's not the court reporter's work, but the court can weigh it whatever it wants. It's just a refresher on two more issues, and they deal specifically with Ms. Love making an objection one to Mr. Adams' cross-examination, and then testifying in front of the jury that there'll be no witness to say what Mr. Adams asked on cross, and that no witness appears on the witness list as well. And then the second one is that Ms. Love cross-examined Ms. Bennett and said that Ms. Bennett sent communications to people in the district attorney's office that you could not make her testify and that you can kiss her a blank. And those did not occur according to the text messages that the court ordered given to us.
Well, there is a, so you're not arguing blind, okay?
Oh, wow. That was interesting. So they got Miss Bennett's phone, and they the prosecution have sent over their screenshots. The kiss your ass bit, apparently it's not in there. How about that?
There is a affidavit that was filed in support of that particular material witness warrant. It's under seal for obvious reasons, but there is a affidavit that kind of lays out what she purportedly said. I don't necessarily know if that's memorialized in text messages, so I don't want you.
Yeah, if that affidavit is from Investigator Hamilton of the prosecution's office, it's worthless, in my opinion, because now the accusation of him coming on to Miss Bennett inappropriately, yeah, okay, that's word against word. What's not word against word is Mr. Hamilton trying to provide work for Miss Bennett's son. That is witness tampering, in my opinion. That invalidates anything he has to say, even if it's sworn to in an affidavit.
To go down that rabbit hole thinking that, that's all there is to it, okay?
The question, yeah, that's great. The question, and I appreciate it because I'm not privy to that. The question though asked was, did you send communication? Send to me would be an email, US
Text.
mail, or a text message.
Okay.
So
All right, fair
anyway, Mr. Kokomo, with the court's permission, if he's available to do it, just play them very short, and then I'd like to answer your questions. Is that okay?
Yes, sir.
Keith Adams. And the record should reflect that there's also some people who write in on this at the bottom. And specifically, I'd like everyone to take note that a person who's very, very well respected on following trials said Keith Adams is a phenomenal lawyer. You will see that on the bottom.
Isn't that self-serving? I still want to see if I still got it, okay?
Did you discuss with Mr. Anderson that Jeffrey Williams was going to pay for the heroin that Buck had stolen from your apartment?
Objection, Your Honor, that would be hearsay, and there is no exception for it.
Number one,
Unless, Your Honor, someone's on the list to prove that up, which there's not.
there is, she can,
Yes.
Ms. Love is messy.
I don't know if the court heard it properly in this courtroom, but it's clear Ms. Love said something to the effect of, there is no witness to say anything like that. There's no witness on the witness list.
Yeah, I'll take judicial notice of the official transcript. And if Ms. Weaver will provide the court with that particular part of the transcript for my consideration, even if it's a rough one. Can you play it again for me one more time? And I'll consider it, but I'm gonna take note of what's in the transcript.
Of course.
Okay.
Thank you.
Mr. Kokomo, can you play it again, please? A little louder.
I can get you the date. I have Friday. Are you playing it, Mr. Kokomo? It's Keith Adams cross-examination. I believe it's Friday.
Ghoster asks, is this related to earlier potential witness tampering? That what happened with Miss Bennett? No, earlier witness tampering is a separate issue, I believe, because everybody was somewhat surprised, at least from the defense side, about her testimony. And yeah, a lot of it was, in my opinion, is the surprise effect. Like the state tried to do it go into a matlock moment, which is in most courts, in most states, doing this surprise thing. Ta-da! Here's something completely new. That's more or less an automatic reversal. But Georgia seems to run its own course.
I'll move on.
For you all who are watching over at the Twitters or X, press the heart thingy so you like my content over there too, please.
Did you discuss with Mr. Anderson that Jeffrey Williams was going to pay for the heroin that Buck had stolen from your apartment?
Objection, Your Honor, that would be hearsay, and there is no exception for it.
Number one,
Unless, Your Honor, someone's on the list to prove that up, which there is not.
there is, she cannot,
Oh, unless there's someone on the witness list that can prove it, and there's not. That is what I'm hearing. Uh-oh. You're not allowed to do that.
By telling the jurors, Your Honor, there is
and so
no one who can testify to that, whatever the exact words are. That is testifying in front of the jury. Number two is the exchange between Ms. Love and Ms. Bennett concerning what I believe to be text messages. Understanding what the court said is under seal, which I never saw. But the way that the question is framed is, did Ms. Bennett send communication? Do you have that, Mr. Kokomo? Otherwise, I'm going to continue.
Yeah, this is really good when they can play back what she actually claimed in court.
Yes, I sent that to Mr. Hamilton.
And did you send a communication to anyone in the district attorney's office stating you did not care what the judge said, no one could make you testify, and did you give specific, explicit instructions as to what to tell the judge to do? Objection,
No.
I'll rule the objection.
Did you tell anyone in the district attorney's office that the judge could kiss your ass?
No. I told Mr. Hamilton to have the judge to call me so I could tell him how being harassed. That's exactly what I said.
Your Honor, permission to treat the witness pursuant to Brown?
I'll allow.
So, Your Honor, where I heard the initial part of the question was the same communication to the attorney's office with an explicit whatever message, whatever the words are. So, I target that. To answer your question directly, so those are 2 points that I'd like only Ms. Love can answer. Then Ms. Love talked about on redirect, which was hostile witness cross-examination. Talked about meeting with Ms. Bennett on the bench outside of the courtroom with people nearby. That's what, that's how it came out. Ms. Bennett never agreed that there were people nearby. That was Ms. Love saying that. And then it became just communication of what was said there, and Ms. Love somehow made Ms. Bennett feel so uncomfortable with Bennett harm herself. So you have that series of questions on the courtroom bench. In addition to that, Ms. Love said, is it true that I communicated with you via telephone at various times? This is during the, I'm not sure which day, I believe it's the second day on who's arrested. And then Ms. Love said, isn't it true that I called you to check on you, on how you were doing? These are quotes from the video. I'm not saying the court. Isn't it true that I told you I wanted you to speak with our victim witness advocate at this office? Isn't it true? I asked you about Jeffrey Williams while we were in the Wendy's parking lot. Wendy's parking lot had investigator Randolph with them. I have no idea what investigator Randolph heard or knows he took it. So, isn't it true that I asked you whether Mr. Anderson said Mike Anderson and Jeffrey Williams were friends before Anderson in 2013? Isn't it true you never once said that this did not occur? Isn't it true I came outside and sat down on the bench next to you? Isn't it true I asked you how you're doing? Isn't it true you told me you were beginning to feel like you wanted to harm yourself again? Isn't it true I asked you what caused you to feel this way? Isn't it true you told me, you, Ms. Love, you were the reason I'm starting to feel this way? Isn't it true that I then left your presence? Isn't it true that never once did you tell anyone in the district attorney's office that this incident where you alleged that the young Thug, Thug DK and Thug's brother Rocky did not occur? That includes Ms. Love as a witness in anyone in the district attorney's office. Isn't it true? The only thing we told you had to do was appear, and I can't understand it. Something about a subpoena. Isn't it true that on May 13, 2013, I had never spoken with you in my life? Did I ask you about Donovan Thomas when we met? I believe it's at the Wendy's, Your Honor, so investigator Randolph would be around that area. No idea what I heard. You remember tearing up when I asked you about Donovan Thomas. So did we talk about him getting killed when you and I met? Did you indicate that it was messed up what happened to him? I didn't, nobody did this. Ms. Love injected herself into the proceedings. It's not a waiver here. She decided to do it on her own. We don't have to sit here and stop her from becoming a witness.
Did you object at the times that she said all these?
There's no objection. She's
By any of you? No. But don't you have to object, preserve the, or let the court
No,
know
you
at
don't.
that point in time?
This is
That's
an
one of the
unforced
issues the
error.
state's raised,
This,
is that you all
Judge,
failed to
this is an
timely object.
unforced error. You clown.
Respectfully, because this is not on an appeal where I didn't ask for her to become a witness. The case that the state cites is a contemporaneous objection rule when you want to stop the question. Ms. Love decided voluntarily and freely to interject herself in the proceedings. There's no objection.
But no, you
She's
still have to
becoming a
object.
witness. No.
I disagree with you. You still have to object as soon as they're
No.
realize that there's an issue,
No.
to preserve the issue
Judge,
so that
this is unforced
the
error.
appellate court doesn't kind of tell you waiver, right?
But what's the issue?
The issue is what you just told me,
No, the
that she's injecting herself as a witness.
And that's okay.
I mean, that's what your allegation is.
That's okay, though.
Okay, but that kind of at least preserves the issue for the court to consider then and make a ruling on it.
The court is considering now, did Ms. Love become a witness in the
Okay,
case?
all right, then the other thing is we haven't completed the examination of Ms. Bennett. So all the conversations, and this is why I asked you to kind of limit as to the conversations that you believe Ms. Love had, and there's no other third party, because you can certainly examine the witness about those particular statements that were allegedly made, or the third party can be examined at some point.
Okay, sorry.
I'm sorry. So that's why I asked you. I'm more concerned about those conversations that you claim where it was just Miss Love and the witness, and she is purportedly, as you said, interjected herself into the matter.
So I gave you two pristine examples that cannot go without the jurors understanding it. The first one is, did you send, this is Ms. Love's words, did you send a communication to anyone in district attorney's office stating you did not care what the judge said, no one could make you testify, and did you give explicit instructions as to what to tell the judge to do? That is a question. The answer is no. The answer is no. Ms. Bennett said no. So there's nobody else in this planet that I can go to ask, why did Ms. Love say that? In addition, saying to the Honorable Keith Adams' question, there's no witness who's going to come in and testify to that. There's no witness on the witness list. Ms. Love, that's Ms. Love's statement in front of the jury. She has no right. That is a witness.
But what about the when the case law indicates, and you all know this, that statements of counsel are not to be considered as evidence.
But that you cannot do that. When Ms. Love, that's not an objection. That is a statement to influence the jury. There is no witness.
I think a few of you have done that during this trial. And that is just something that it's a practice that is not permitted. It's really not condoned at all. But that you're.
I thought if this judge could find a loophole, he would use it. I did not expect him to fundamentally ignore law. This is an unforced error. It does not need an objection. This is in violation of the bar code, of the ethics rules. There are law, rule, ethics. Unforced error. There's no need for an objection. You absolute Jesus. It's stringent. This is a reversible error, getting the actual law wrong. Yeah. Here's the thing. That could take years. Years.
Really not supposed to comment in front of a jury improperly.
Judge, Ms. Love put her own credibility in front of this jury. There is no way to erase it. There's no limiting instructions.
But I'm going to charge the jury at the end of this case that statements of counsel, opening statements, closing arguments, the questions asked by counsel are not to be considered as evidence. They're not.
Mr. Williams has the right to cross-examine.
I do. You do, and that's why I'm asking you about the times that she has.
I gave them to you.
Okay, so
I gave you all those times about telephone conversations. There were just the two of them.
So you're saying the two areas that I'll take judicial notice of, as well as anything that's been on the transcript, and that was on the 25th of March.
Not that I believe. I think it was the 28th and 29th of March.
28, 29 March. I'll consider those. And then the other ones you point out for my consideration are the communications on the bench outside the courtroom. Is that correct?
Bench outside the courtroom. And then how do you get around the text message when it's not supported by the text message?
What text message? Which ones you talking about?
When Ms. Love specifically said, and did you send a communication to anyone in the district attorney's office stating that you did not care what the judge said, no one can make you testify, and did you give an explicit instructions as to what you tell the judge to do?
What court, what exhibit was that, or trial exhibit was that was introduced? We need to refer for the record.
That's fine. That's going to be in all the text messages. I don't know what the state called it, but the question.
Let me just pause a second.
Sure.
Mr. Houski or Ms. Weaver, do you know what court exhibit or what exhibit that was? But I need to reference it for the record anyway, so. Just give me 1 second, please.
We're almost caught up here. Yeah, GD says put Ms. Love on the witness list. Yeah, in order to do that, they need the judge's approval. They need, and he won't do that. Now, he might change his mind. I don't expect him to, but I did not expect this judge to completely ignore. If the prosecution does unforced error, there is no obligation from the defense to object. In my opinion. US-based legal scholars can they can agree or disagree with me. That is my opinion. Don't take my word for it. I don't practice in Georgia or the United States. But in my opinion, after reading the defense motion and the prosecution's reply, in my opinion,
I'm having front of me states 33.
There's no way the judge has not anything else but two options: removing Ms. Love or mistrial, probably with prejudice. But
Alpha states 34 alpha and states 35 alpha. If you want to take a look at them and tell me exactly where it is that, in either one of those three, also have 32 alpha
that's
and
the
alpha.
prosecution's. Why are you arguing at the behalf of the prosecution? In a hearing, when you have the defense motion and a reply from the prosecution, the defense is supposed to argue more about their own motion to the judge. Then the judge turns to the prosecution. What is your reply? I've read your reply. Bum, ba, bum, ba, bum, ba, bum. Then ask, okay, dun, da, dun, da, da. What is your reply to this, Mr. Steele? Bum, ba, bum, ba, bum. Okay, here's my ruling. That is how it is supposed to go. Yeah.
There's also states 32 alpha, which is the purports to be the text messages from Miss Bennett's son. Yes, you can, sir.
This is on 34A.
34 alpha.
Give them all back.
All right, thank you. Okay, all right.
And the statement made by Ms. Love that I've
Okay, and 34 alpha.
Right, that is the closest you're going to get to.
Which statement are you referring to in this
Okay.
exhibit?
Miss Love, the one I handed to you, but Miss Love stated in front of the jury, she testified. And did you send a communication to anyone in the district attorney's office stating you did not care what the judge said? No one could make you testify and did you give explicit instructions as to what to tell the judge to do? And in the document I just gave,
34 alpha.
that is not even close to a fair summary of what is written by Ms. Bennett. And Ms. Bennett specifically said, no, that is not what I said. And the only person who can be challenged on that testimony, because that's what it was, is Ms. Love. And the state's case that they cited to you, which is Bonner, B-O-N-N-E-R versus State, 192 Georgia Appeal, 721 1989 case. And the state said that this is the only case in Georgia on point. I don't agree with that, but that's what they wrote. And in Bonner, it actually helps Mr. Williams, because in Bonner, what happened was the prosecutor.
What's the citation for Bonner again?
Your Honor, it's 192 Georgia Appeal.
Yeah, the Bonner restate, which I told you about yesterday evening, that is one question, extremely narrowed down. And it was on the defense witness, on the state's cross-examination of that witness. This is the state's witness on the rebuttal of the cross-examination. So the facts, the bottom facts are different. So Ms. Fani Willis, yeah, I've told you enough of what I think about Fani Willis. And 111 likes and 243 watching. We should get, Gigi says 200 likes. I will settle for 150. So come on, folks. You know how to do this. It's YouTube's. You all know how to do this. W. McMaster. Wow, this is the chief judge too? Yeah. This is the chief judge. He's the boss of the other judges. It's
721 386 Southeast 2D 379
I need to blow
1989.
my
192
nose.
Georgia Appeal, what? I'm sorry,
721. It's a short opinion. It's in Division 3.
Nasal spray, so I can talk for a bit more. Didn't the judge said he read this already? Apparently not. I did. And I don't even get paid to do this. Hint, hint. Yeah, here's the thing. I haven't monetized this stream. It will get monetized the last 20 minutes, and the replay crew will get a few ads, so I get a few dollars for this. But if you want to, I don't mind super chats or gifted membership.
Okay, Bonner, which is, as you indicated, 192 Georgia Appeal 721.
So I find this case to be fabulous for Mr. Williams. In Division 3, the court wrote that the transcript reveals, in regard to appellant's final enumeration, that after appellant testified on direct examination that she had not visited the victim's bedroom, the district attorney cross-examined appellant about a statement she had made to the district attorney himself prior to trial. The district attorney called to appellant's mind the time, place, and circumstances surrounding the conversation, in which appellant was asked whether she told the district attorney that she went back into the victim's bedroom to listen to the radio. Now I'm skipping, Your Honor, to the end of the opinion.
Well, I don't want you to skip. I want you to kind of also take a look at what there's an objection that was interposed on an unsworn witness.
Yeah, but I'm saying
Okay,
that
so-
she needs to testify. I don't care that she became a witness. I
But
want to
that
cross it out.
preserved the issue for appellate review and for the court to kind of take it up. That's one of the things the state's saying that you should have done at that point. in
No,
time. But
I don't.
we'll
okay.
continue with it. But
All right.
anyways, but yes.
Jesus Christ.
Keep reading, or can I go
No,
to?
go ahead. Yeah.
So if you go to the very end of the opinion, I don't know how many lines because we're not looking at the same,
Yes, sir.
but at the end of the opinion, if you could target, it's maybe, I don't know, 12 lines up. The transcript reveals that the district attorney laid the proper foundation, but rather, and this is what I stress, but rather than denying making the statement, appellant admitted.
Ken's counseling coach disliked because Nick want murderers who confessed in the song lyrics to be able to walk the streets. No, I want due process. That's it. And if the Georgia Supreme Court says whatever, here's the thing. Take anything other than rap lyrics. Take death metal, black metal. Are we supposed to, this is an admission of wanting to whatever's with Christians. That's a preparation of blah, 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 blah. No, it is all, it is just lyrics. Unless it is, they can pinpoint, I did this rap with that one rap at this time rap. That is a confession. Maybe. If those lyrics align with the actual crime. Popping a cap, paying 30 G's to a lawyer, that's not a mission. Jesus, it's not that odd.
Having done so. Thus, contrary to appellant's contention, the transcript established that it was not necessary for the district attorney as the cross-examiner to prove the making of a statement. And accordingly, we find that the failure of the district attorney to be sworn as a witness and to be available for cross-examination by appellant did not constitute reversible error. Here, Ms. Bennett denied making that statement. She denies Ms. Love's assertion in her question about give explicit instructions as to what to tell you, and that you could not, she did not.
Yeah, that is another difference between that case and this case. In that case, the witness said, yeah. In this case, the witness said, no. Then you have the district attorney asserting to the jury, I'm credible, believe me, not the witness. Here's the thing, the ADA Love, not sworn in. It's an unsworn witness. I mean, the rules are so clear. The law is over clear. The ethics code is super clear. And the judge,
care what you said. The text message that I gave you, and I didn't count the pages, but it is in that exhibit in blue at the top, is Ms. Bennett saying, I'll explain it to the judge. She was polite about the court. She was not rude. That is something that.
Ken's counseling coach. I was cosplaying as a law Karen. Okay. So I should have known. You've been here long enough for me to realize that. My apologies. Yeah.
Needs to go to jury for this reason. And this is the important reason. Ms. Bennett is exculpatory to Mr. Williams. This is not like you can strike or you can give an instruction. She is exculpatory. And what Ms. Love did is three witnesses, one lawyer and two witnesses, she decimated their credibility. She's telling the jurors that Ms. Bennett is lawless, doesn't give anything about you. That will bother the jurors. They will discount her. Number two, she tells the jurors that the Honorable Keith Adams' question is made up by Keith Adams. He's not truthful. And third, she has decimated the credibility of the witness who has not yet been called because she has said there is no witness who is on the witness list who will testify to that. So when the witness does come in and testify to it, the jurors are already clued in, that is a lie. Ms. Love knows exactly what she's doing, and she is testifying for the jury, and we have questions for her. And the questions are simple.
All right, let's focus, because the focus is on, remember, statements of counsel are not to be considered as evidence anyways, but focus on the issue of Ms. Love and the statements that she purportedly has made to Ms. Bennett.
It is evidence when the ADA Love is making statements of fact that are contested. Then it becomes evidence because she's an unsworn witness speaking into the record in front of the jury without being sworn in. She cannot be cross-examined, especially since apparently her question, asserting herself and her opinion into that question to Ms. Bennett. Ms. Bennett said no, and when they have reviewed the text messages, it's not a fair assessment of what was actually said. That puts Ms. Bennett against ADA Love. That makes her, ADA Love, in my opinion, a material witness who should be cross-examined since she made a misrepresentation of things that are not yet in evidence.
You can't examine. How come you can't examine Ms. Bennett on the stand about those statements and utilize the text messages?
Because I would say to Ms. Bennett, what did Ms. Love mean when she said, did you send a communication to anyone in the district attorney's office stating that you do not care what the judge said and no one could make you testify and did you give an explicit instruction as to what to tell the judge to do? And the answer is going to be, I have no idea what Ms. Love was thinking. I don't know why she asked me that question. I already told you that's not true. So you have to ask Ms. Love, why would you say that? Why did you put in the juror's mind that this witness is underneath the law? That she curses at the judge? That the judge can kiss her
ass.
Well, I don't want to say it, but
Well, here's the thing as well. I mean, if that's what you're looking to get at to impeach her to get her, I think there's another methodology of doing
No,
I don't
Your
believe I
Honor.
know that methodology.
that. No, I'm telling you that I told you that there may be a exhibit that, like I said, they have a material witness warrant, and for good cause, I'd be willing to unseal it and you can look at it.
I'll look at it.
And that may, I'm telling you from the court's perspective that
The court's
if
perspective
you're
is
because
wrong.
if you're attempting to have Ms. Love explain this, I mean, even though counsel shouldn't inject themselves as a witness, I understand that, but I do
Shouldn't,
believe
yeah.
that
It's the
there is
rule, the
there
code,
is some
the
conversation.
ethics.
This references conversations that are in an affidavit that you may be able to use to further examine the witness.
That does not comport with the question, did you send a communication?
Convict.
That's my point. I don't care what the affidavit says.
Okay, but
I think you're doing
what
great by
Did you
yourself.
send a communication? That was the question.
who said that, Ms. Love?
Yes. That is a quote. And I know we go by court reporter, but that is the quote online from the trial. In addition to that,
Okay, well, flush out did you send a communication?
right? That is not the spoken word. Send a communication is email, a letter, text message.
What did Ms. Bennett say about that?
And that goes to the Bishop case. She said no. And the Bishop case said, well, she would have said yes, then what's the point of cross-examination? And Your Honor, I hear what you said and I respect it. And you said it multiple times. Look, the jurors are going to be told that the lawyer's questions are not evidence. But that would do away with the unsworn witness rule. Every case, I have cases I cite you from 2nd Circuit, 3rd Circuit, 7th Circuit, 6th Circuit, 8th Circuit, 9th Circuit, 10th Circuit, 11th Circuit, U.S. Supreme Court, Georgia. Every one of them say the lawyer can't inject their personal knowledge as if they are vouching for it. And that's what Ms. Love did. It doesn't matter that you can tell the jurors that the questions of the lawyers are not to be used as evidence. The answer.
Question from OBZ. Can they report her to the bar during a trial or do they have to wait until it's done? They can report her at any time. Now, it's very rare for a lawyer to report another lawyer to the bar. I think this is one of the occasions because, in my opinion, Ms. Love is in clear violation of the bar code, the ethic rules, and state and federal law and statutes. I don't understand why this judge is so adamant in allowing any piece of garbage the prosecution throws out there. I cannot understand it. Thank you for your question.
Is that Ms. Love deliberately, intentionally, knowingly, and voluntarily injected herself to make her credibility as a prosecutor. We value prosecutors. We all value prosecutors. They have tremendous power that we bend down to and say, we give you this power. And Ms. Love has wielded that power wrongly. And she's not asking questions, she's saying, me, did you tell me? Did you send the communication? She's holding text messages while she's doing that. Did you send communication? She is calling this witness, Mr. Adams, and the witness who has not yet been called, that it's not true. And I've never heard an objection except from this prosecutor where they put in evidence. Judge, this will not come into evidence. There's no witness to say that. That is testifying. And it needs to be explained. And I don't know why we're here. This was not my intention. And no, I didn't waive it. And we don't have to sit here. We don't lay in wait. Ms.
Well,
Love was
Bonner
doing
seems
this.
to indicate that that there was an objection made as to the unsworn witness. That's exactly what the basis for the objection was. You didn't make one.
Yeah, but you got to read further in these other cases. I'm asking for Ms. Love to become a witness. She enveloped herself. She's intrinsically into.
And the judge goes by, well, you didn't object. You do not need to object to unforced errors. It is good that you do, but it's really not needed. That's why they put in the motion. That's why they told Your Honor directly at the break, Your Honor, she made herself an unsworn witness.
Twined for whatever reason in what she did in the case. I understand that she said that other people around her on the bench. Other people around does not mean that they were part of the communication. Other people around doesn't mean they heard everything. The telephone calls that Miss Love had, we don't accept that it was on a speakerphone with someone else there. She's texting the woman on New Year's, telling her what a great mother she is. What a symbol, and I'm not quoting now, but a symbol of the community she is. You know, these are inappropriate, and lawyers aren't supposed to make lawyers the object of the trial. Miss Love made herself the object of the trial, tried to cut the knees out for Mr. Adams by saying he has no right to ask that question because there's no witness who will say it. Those are all the wrongs that the ethical code and the case law tell us to do. I'm very aware of your time limit. I know there was issues.
No, I'm gonna let you have a little more time. So,
But
tell me about the Rule 3.7. If there's any other case law that seems to that you want to point to my attention from Georgia, all the other of course states.
Yeah. Regarding what cases there are in Georgia, there are not many. Why? Because no one is as stupid as Miss Love has been in this trial. That is why this is so rare. It's so rare in Georgia and in any other state that most of these things don't have to be argued in a motion. The judge himself could have from the bench said, not allowed. Why didn't he do that? Well, because his nose is too far up Ms. Love's ass.
Persuasive, but is there anything else that our Georgia courts have indicated that would make out your argument in terms of the unsworn witness? And also, of course, it's discouraged that lawyers are witnesses anyway. So, and unless they're testifying, consistent with the proper circumstances.
Yes, to answer your question. I believe I cited it. Let me just pull it up.
Yeah, and the reason why Ms. Love,
It is a case, I believe.
the reason why Ms. Love doesn't seem to be in court at the moment is that she might be called in to be asked questions by the judge. So she's not supposed to hear this. And I would assume that DA Fani Willis would be here to argue the state's case, but it seems like the prosecutor is doing this for her.
The Honorable Bruce Harvey did. To quote Bruce Harvey, when cases were cases, 1985.
Is that when we had paper advance sheets?
Yeah.
Okay, all right.
It's actually before my time, but I don't mean that to Mr. Harvey. It's Castell, C-A-S-T-E-L-L versus Kemp. C-A-S-T-E-L-L versus Kemp. It's 254 Georgia, 556.
So you said 254 Georgia?
556. It's in your package if you
Okay.
care. And it's 331 Southeast 2D, 528. It's 1985. And if you look at the left-hand side of the copy I've given this honorable court in the
Of course
parties,
she is.
you will see counsel, the Honorable Bruce.
Just because Ms. Love isn't in court and isn't supposed to listen to this, of course she is, because she's an unethical bitch.
Harvey.
Is in this packet of materials you gave me?
Yes, it is.
I thought you were prepared, Your Honor. Apparently not.
Fifth case, it should be.
Are we at 150 likes yet, by the way? Let me check.
The case I have is Dillon versus Collins.
Right
Hey,
after.
158.
Yeah,
Nice.
next case, Your Honor.
Now
People
let's go
versus
for
cocaine.
200.
You should have, it's a small case, so it may, the staples may have clipped together, but it's Castell, C-A-S-T-E-L-L versus Kemp.
Jack West.
Should be the fifth one.
Thank
Your Honor, I have another copy.
Thank
Yes,
you
sir, you
for about my cold. It's slightly better, but I'm still running a bit of a fever. I'm going to bed directly after this stream is done.
All right,
Oh.
sir, I now have,
By the way, before I forget, 9 p.m. Eastern Time, I will join Larry, the DUI guy, on his channel talking about the Delphi case, because he is getting involved in that case. So I'm going to give him a run through of what happened the past 7 years. Good luck to me.
Sal versus Kemp.
So on the second page, the left-hand side,
Yes, sir.
the
I will
12th line
not
in the
stream
center.
from bed.
The roles of an advocate and of a witness are inconsistent. The function of an advocate is to advance or argue the case of another, while that of a witness is to state facts objectively. And then it said State Bar of Georgia's Code of Responsibility, Ethical Code 5-9, 1983. Furthermore, where the question arises, doubts should be resolved in favor of the lawyer testifying and against his continuing as an advocate. And that again cites to the Ethical Code. And then on the right-hand side, the second full paragraph, the rules of the Code of Professional Responsibility do have the effect of law. Although only couched in aspirational terms, these rules cannot be ignored if we are to maintain integrity and credibility of our judicial process. So I believe that shows that the Ethical Code is in play here when a prosecutor does what Prosecutor Love did. And it's worse when it's a prosecutor. All these cases I cited to the court, they all say when you're talking about a prosecutor becoming a witness, it is triggering rights of the accused, as opposed to other lawyers where you might just say what the lawyer says is not evidence. Here, the prosecutor has to be looking out for the rights of everybody. That's why there's Brady obligations. And in this case, Ms. Love just went way over the top and injected herself. Your Honor, the United States versus Hosford, H-O-S-F-O-R-D, which should be the first case against Honorable Court and the parties, which is 782F.2D 936. It's 11th Circuit, 1986. In that case, the AUSA, his name is McGee, MC-G-E-D, did not formally appear as a witness, but he was cross-examined. And I mean, he was doing cross-examination and he was involved in the facts of the case like Ms. Love. And on page 3 of 5, the 11th Circuit goes through a 4-part analysis. On the right-hand side, the 7th line in the center, specifically, I think this applies. The 11th Circuit said that third, the performance of the dual roles by a prosecutor might create confusion on the part of the trier of fact as to whether the prosecutor is speaking in the capacity of an advocate or of a witness, thus raising the possibility of the trier of fact, of the trier according testimonial credit to the prosecutor's closing argument. And here, that's what we have. We have the cross-examination or the redirect examination or the direct examination of a, quote, hostile witness, where Ms. Love is, through her questionings, raising the possibility that the jury will think that they're giving testimonial credit to what she's saying. You can't ignore that, and you can't erase it. The fourth one, right after that, the 11th Circuit wrote, fourth, the rule reflects a broader concern for public confidence in the administration of justice and implements the maxim that justice must satisfy the appearance of justice. This concern is especially significant where the testifying attorney represents the prosecuting arm of a federal government. And I don't know how we got here. I don't know why the state thinks that this is no big deal, just cross-examine someone else. This is exactly what we don't do. It's an ethical violation. It is a lawful, legal violation. And I ask this honorable court to disqualify Ms. Love from going forward in our case. She will be a witness in the case. And we will ask her, we'll telegraph her what concerns we have. Why did she, I told you, what did she do at the bench to make what did she do?
Outside bench, that conversation that was had reportedly outside.
Right, what Ms. Love reported to us. That one, where others were around, that's how it was said, others were around, not others were participants. The telephone calls, the announcement in front of the jury, it's not an objection to say there is no witness who will say what Mr. Adams said, that this was a theft and Jeffrey Williams repaid the theft. And did you send, Ms. Bennett, did you send communication that the judge, I'm not going to go through it again, but inappropriate things towards this court? And the answer was no. So that's why Bonner, I believe it's helpful.
All right.
No, Your Honor, thank you very much.
Okay, all right. Mr. Helsky?
And by,
Oh, Fani Willis, you cowardly bitch. You wrote the reply and you don't even show up to court. Oh, what a coward she is. Here's the thing. She's trying to repair her reputation. However, you can repair the reputation of a harlot who sleeps with a married man that we know of. So, of course, she didn't show up to court, because her showing up in court, talking about credibility and ethics, not a good look. Could be used against her. You coward. You coward. Spineless coward, Fani Willis. Making a junior prosecutor argue for her. You coward.
can I say one other thing? Do you mind if I just say one? Your Honor, I looked at my notes. It is Thursday as well as Friday, not just, I think I said earlier Friday. It is Thursday, some of these concerns. They came up on both direct and redirect.
All right, Mr. Helsky, go ahead.
Yes, Your Honor. Let's start with 3.7.
I'm sorry, start with what?
Rule 3.7. The lawyer as witness professional conduct rule. I wanted to point out about Castell and in connection with 3.7, just while it's at the front of mind. Castell was a case where Bruce Harvey tried to argue his own ineffective assistance. That's the conflict that we're cited to when we're talking about Castell. And when we're talking about Rule 3.7, the lawyer as an advocate shouldn't be also a witness. It's true what Mr. Steele says about these rules having binding effect, but there's nothing that says that even if there was a 3.7 violation, which we dispute, of course, that the remedy is disqualification of the prosecutor. The remedy, as far as I remember looking it up just yesterday, was public reprimand if there was a 3.7 violation in the first place.
So that's not from me. That's the collateral offense,
Sure.
the collateral consequence. The legal consequence for the trial would be for they've asked me to consider that she'd be disqualified.
Sure, but I guess the larger point about Castell, going back, is the idea of an attorney on a habeas to argue that their own performance at trial was ineffective. That's kind of an impossible conflict of interest. So I don't think we have anything resembling that here. And I want to go to the questions that Mr. Steele was getting into, and I'm not going to get too much back into the briefing because I know Your Honor has digested that. But starting with the comment about Mr. Adams's question about Buck or whatever that was. So it was a hearsay objection, and then it was followed up with, hey, there's not going to be a witness on the witness list. That's the attorney.
You'd agree that she shouldn't have said that.
At best, it's a speaking objection. And if the remedy for a speaking objection, Your Honor, is disqualification, guess how many defense attorneys we have left? You see what I'm saying? So at best, it's a speaking objection, and that's improper, but it's not the lawyer testifying. Again, the jury is presumed to follow the judge's instructions. The judge has, in this case, and will continue to advise the jury that what the lawyers say is not evidence. And in that connection, Your Honor, I want to point to one of the cases. I'm not going to belabor it, but Palmer v. States, and this is on page 4 of the state's brief. It's a Georgia Supreme Court case. It's 236 Georgia 507 at 507 and 508. There they approved of a jury instruction, and I will concede that it was a curative in that case, but it says that the instruction said that anything a prosecutor might say while asking questions on cross-examination was not evidence. So even if you think that was an improper speaking objection, which is not the first one we've seen, the remedy is not disqualification, which, as Your Honor is aware, is a radical remedy. Going forward to this other communication, the second major point.
Anything a prosecutor, lawyer, attorney, defense, anything regarding to what? In what setting? Does anything exclude them from calling a surprise witness? We call Mr. Bean again, even though we released him, because he will say that Mr. Williams did all of these things. Will that be curated? by an instruction. I mean, this is just stupid. This prosecutor knows when a decision says anything, it is still within the corners of that specific decision. It doesn't apply overall. That would be stupid.
Your Honor had asked us to discuss this instance where Ms. Love asked Ms. AB, isn't it true that you sent a communication talking about the judge can kiss your ass? That's just not good phrasing. Send a communication. It doesn't necessarily mean it doesn't say, didn't you send a text? It doesn't say, didn't you send an email? It says, didn't you send a communication? That's just kind of maybe imprecise phrasing. The remedy for imprecise phrasing is not disqualification either. And if you listen to the rest of that question, Ms. Love went on right after that, really kind of interrupting herself and clarified, said, did you tell anyone at the DA office that the judge could kiss your ass? Did you tell anyone that? So she heard her own imprecision, she corrected it, and then the answer was no. So we had this big argument about how Bonner doesn't apply because in Bonner, the witness said yes. Oh no, well in this case, the witness said no. It's a question.
But how are they going to impeach you on it?
However they want. They can cross-examine her. They have the text, every single text that anybody had with Bennett. Those speak for themselves. They can cross.
That doesn't relieve Ms. Love from being a witness. They don't need to cross-examine Ms. Bennett because she already said no. There is no such thing. Okay, then you have two people say one saying one thing, one saying another. You have to cross-examine and interview the witness who said opposed to the witness on the stand, and that is Ms. Love.
And the very next witness that I believe the state may call in relation to AB is going to be the investigator who was going to be present for these communications. And just to clarify, which I think wasn't clear.
Investigator Hamilton will take the stand.
We're not saying, and it's not true that Ms. AB ever sent a text that said the judge can do this. That was an oral statement that was made. And Ms. Love said, hey, didn't you tell me this? And we can ask Ms. AB about it. We can ask the investigator who swore an affidavit to that effect, which Your Honor is aware of. And so there's no unsworn witness violation. And I'm not going to make too much more, fodder of the Rule 3.7 stuff and the idea of like preserving objections, because it's true what Mr. Steele says. That is an appellate doctrine. And, if you don't object to it, you waive it. The contemporaneous objection rule says if you don't object by the time the next question comes, you've waived it for appellate review, and that plain error and stuff, all that still applies for an appellate matter. I just wanted to point out that the sort of artful practice that you see here is a little bit concerning, especially when you look at the sort of injection that happened with Mr. AB when it comes to lawyers asserting potentially facts not in evidence, becoming part of the evidence. Again, if disqualification were the remedy here for what is alleged, and we're not even conceding that the allegations are true, but if disqualification were the remedy, where's the Georgia case that says that? And if indeed that was the remedy, again, like bye-bye defense lawyers, because Your Honor's been aware of this going on both sides. We have we have permission to lead a witness. Okay, that's proper under Brown. When you're asking a leading question, it's always going to presuppose some sort of desired response. That's just the textbook way that works. The fact that we have communications with the state's witness prior to that state's witness testimony, and that somehow is being made into a disqualification grounds, that's just prepping a witness. That's just trial practice. You can't avoid that. You're going to have to communicate with the witnesses to get them up on the stand, especially.
Communication with the witness has its limitations. You can't do anything in communications with a witness, especially not when you almost plan to ask her questions about statements that are not recorded. Now, had these been recorded, then okay. Now, do I believe if they call Mr. Hamilton to testify about this, I don't see how Mr. Hamilton can liberate Ms. Love from the obligation of, because if Mr. Hamilton goes up and testifies, well, I heard that Ms. Love said, hearsay. Jesus Christ.
To difficult witnesses in high profile cases. So again, what the lawyers say is not evidence. The jury know that. And they're going to be told that, and they're going to follow that.
Okay, let's assume I believe that, or that assertion based on the text messages, that at least were in states 34 alpha alpha. What about the communications that Ms. Love had with Ms. Bennett on the benches outside the courtroom that were not memorialized or witnessed by a third party?
I don't believe that any such communications exist. Ms. Bennett said nobody was nearby. That's her answer, but that's not necessarily what reflects the truth.
You don't believe that's a problem? I mean, how is the defense or anybody else going to test that? Then you are being asked to look at the credibility of lawyer versus witness because you don't have a third party.
Well, that's what Ms. Bennett says, that there's no third party. That doesn't mean we don't have a third party. I mean,
Was there a third party present?
I believe
during all of the conversation?
As a matter of protocol for these conversations, I believe there's going to have to be an investigator or a victim witness advocate. I believe Ms. Lieutenant, I mean, I'm not going to speak.
They can only testify to what they witnessed. If there are any other communications, and here we go back to, for instance, in the Delphi case, where the judge made a horrifyingly bad decision yesterday or a few days ago. The investigators in that case lost 70 days of interviews. They didn't even take notes on it. The defense there argued that we can't prove because it's gone. The prosecution and the investigators lost the evidence. Therefore, you must believe that this is exculpatory for us. And the judge said, no, you can't prove there was any exculpatory in the deleted evidence. Well, of course they can't prove it because the investigators deleted it. This seems to be the similar here. Well, we can call an investigator and a victim's advocate, and they will say they heard this. Yeah, but that doesn't exclude any other time with communications. This should go in its entirety towards the defense because the defendant has rights. There's nowhere in the Constitution where it says the government have the right to be assholes in court. Nowhere. And why is that? That is to avoid government misconduct. That is what the Constitution is about. That is why sometimes we let criminals go, because investigators and prosecutors are morons and ineffective and incompetent. That's the price of liberty, that sometimes criminals go free. And it's heartbreaking when it happens. But the other way around, that's communism. Don't be communist.
I wasn't there, but as a matter of protocol, you get in a lot of trouble if you don't do that. So if we have investigators present when we're dealing with our witnesses, and just because Ms. AB said no, there weren't people nearby. I mean,
okay, well, I'm just look. They're asking me for a draconian, remedy, which is,
indeed,
hey, look.
It's not draconian.
She had conversations, Ms. Love purportedly had conversations with Ms. Bennett, and nobody else was present. That's what Ms. Bennett seems to have indicated. So, are you telling me that if need be, the defense can cross-examine or has the ability to call, if appropriate, the third parties that may have been present, victim advocate or the investigator?
On information belief, yes, I believe that will be possible.
They were present the entire time? Yeah, of Ms. Love's conversation? Other than when she said, we're going to leave. I'm going to leave because you're making me angry.
Other than the, kind of texts about this or that administrative detail, like, Happy New Year or whatever it is, these collateral matters. Yeah, I believe there would have had to have been an investigator present for any of these.
Had to have been, or there was? Because I mean, look, if you don't know, you don't know. But I mean, that's kind of Mr. Seal's point. I mean, because if you're going to represent me as an officer of the court, yeah.
I still say that the correct way to handle this would have been defense. Here's our motion. Okay, state what is your reply. This is our reply. Okay, defense, what is your reply? Here's my ruling. Now, judge now is acting as an appellate judge. Apparently, that's the way they do it in Georgia.
We had, despite the fact of what she may have said, Judge, we had somebody that was there the entirety of the time, or can refute or rebut that assertion. That's the assertion right now. That's what I kind of want to get some clarity on. So if you want to, just let me know before you commit to that. I know what your assumption is and practice is, but I want to know whether or not she had conversation, she being Miss Love had conversations that were witnessed by some particular member of your team that would refute or otherwise not make this an issue, because it's an issue only because there's no way I can test if that truly was a conversation. There's no way as the cross examiner I can test whether or not that third party was this witness is telling me what really happened.
Okay, so
I'm going to hold on that. And let
I
you,
have an update on that.
okay.
I believe the conversation that we're referring to, I'm being told there was an investigator present, Antonio Long was present for that.
Okay, all right. So if need be, Mr. Long can be, if appropriate, can be examined on that. Okay, all right. What about what about the third group of statements? This communication by telephone at various times between Ms. Love and Ms. Bennett. And I want to say that is, let's see. And you all might be able to help me out with that. Which one of the state's exhibits, 33, 34, or 35, are the ones that there's the assertions of that Miss Love is having a conversation with Miss Bennett? Can one of y'all tell me?
So the text conversations that have occurred between anybody and Miss Bennett, anyone in the DA with Miss Bennett, those the court has, all the parties have all those.
Those are 33, 34, and 35 alpha.
I believe so.
All right, but I want to know which ones of these conversations are the conversations purportedly that Miss Love had with Miss Bennett? Because some of them are just talking about.
Oh, Jesus Christ! You sent in text without asserting from who they were sent? Jesus Christ.
The son having and getting a job or helping the son get a job. Some of them are just pleasantries of the greetings of the season.
Offering getting the job.
I mean, I'm not concerned about those. I'm more concerned about just about anything that may have been said that maybe wasn't witnessed, that might be problematic. That's what I'm trying to look at this time.
Well, I mean, from my understanding, the text messages largely occur between Lieutenant Hamilton and either Miss AB through her son's phone or her direct phone. Again, when you're talking about conversations about, coming to court, just pleasantries and stuff like that, I'm not aware of any conversation that happened that was of substance that wouldn't have been witnessed by an investigator or some other advocate per protocol. I mean, I'm not the universe of all the potential things that could have been said. I mean, I'm not really in a position to represent like what may or may not.
Well, if you can't represent that there have been witnesses to all the communications between Miss Love and Miss Bennett, then Miss Love is the person to testify. You can't get around that.
Have happened over the phone, but there's not going to be anything substantial as far as any oral statements that wouldn't be covered by this investigative protocol. And again, these texts, they've been turned over. They speak for themselves. This AB can be cross-examined on any of this stuff, including the oral statements. I understand the court's
kind of shifted on to you, Mr. Yahowski, and your team in regards to, because Mr. Steele has said, okay, listen, that's why, maybe what I need to do is I need to let you all take a look at 33, 34, and 35 alpha and parse out for me, because as they were sent to all councils a couple days ago, some
$50 in super chats or gifted memberships buys you a shot of whiskey, and it buys me a shot of whiskey. All right. Or do you want to have the Wheel of Regrets up? I mean, it's 5 p.m. here. You let me know if you want the Wheel of Regrets up in this. then it's $50 per spin on the Wheel of Regrets. For you who are wondering, what is the Wheel of Regrets? This is the Wheel of Regrets. That is me grifting for a bit of super chats and stuff. So $50 in super chats or gifted memberships or via PayPal or something buys you a spin on the wheel, and I will do whatever comes up, as in this case. So had we been at $50 in super chats or gifted memberships, I would have had this one, the Inferno chili sauce with Scorpion Moruga chili. But we aren't there yet.
More conversations had with two of your investigators. One of them being Investigator Long, Chief Investigator Long. The other one was with, I want to say, Investigator Hamilton. And then the other one was reportedly with Miss Love. So there's 3 sets, I think, of text messages. That's kind of what I need you to kind of look at. I need you to look at this last set of communication at various times of who within those particular exhibits had text message conversations. The one I'm focusing upon at this point in time is of course, Miss Love. So let me just recess about 10 minutes and let you all kind of look at that. That's kind of what I want to address. I just want to make sure
They should be prepared. They should have been prepared all along for this.
Correct,
Everybody knew.
That's fine.
Okay.
Everybody knew this was being heard. Them not being prepared, don't reward them from not being prepared. You said it yourself, Your Honor. Come prepared. I don't want things to take too long. And here you are. I'll give you some time. Get prepared. Jesus Christ, Your Honor. And now we're apparently live. And they are still on break. Yeah, this is you can't un-F a cluster F. Coincidentally, you can get your own mug in my merch store. I think it's linked in the description. Yeah, so how far have we gone with this today? Well, I said yesterday on that stream, I expect the judge to find loopholes. And it seems like if there is a loophole here, which it shouldn't be, it is, well, you can always call Mr. Hamilton or some other dude or girl. I don't know. But that doesn't... They're close by. So what? You have the correct witness. It is Miss Love. And it was an unforced error. She is the witness to hear on this issue, not her employees. Because as employees testifying against your boss, I mean, for you who don't know, I do labor law. When a person is in, what you call it in English, what's the word I'm looking for here? Well, if you are employed, you are in, what's the word I'm looking for? Help me out here. Thank you, Nana Misty, for gifting 5 memberships. It went to Reform Convict, V. McMaster, View Galaxy, Marjorie Smith, and JB. Congratulations. Everybody say thank you to Nana Misty. Yes, you are subordinate, which means you are in, whatever it is. I can't remember the English word for it. Okay, John Commune gifted 5 memberships. Thank you so much. It was gifted to Stacy Marie, Marta. Come on, live chat. Murph Turf, McKinley Melancon, and Jeremy Alt. Congratulations to you too. That brings us to a grand total of $35. So we are $15 in super chats or gifted memberships from A Spin of the Wheel. Thank you so much, John Commune. Jesus Christ. I have to find the translator. Dun, dun, dun. Well, a subordinate is in... Jesus Christ, why can't I find the word? Whatever. In a lower position, she or he is... Well, if they testify against, that might come back to bite them through retaliation of sorts. That is why their testimony, at least in labor law, is not relied upon as much. Yes, fear of retribution. So in this case, the district attorney's office have already shown what happens to people who do not get in line. We saw that in the Fani Willis disqualification case about Fani Willis' former best friend, whose apartment she used to fool around with Mr. Wade. And when she started to object to certain practices, she got the option, either you're fired or you can leave voluntarily. So Mr. Hamilton, him testifying, I can't take that into account. Or the other one, because they are in reliance due to Miss Love being their boss. But they have an ethics code. How can you not believe them? Yeah, screw that. They have shown throughout this trial what their ethics code is, and it's a non-existent. And we already have evidence into record that Mr. Hamilton offered her, Miss Bennett's son, or tried to facilitate an opportunity for a job for her son. That's witness tampering. Why should we believe him when why should we not believe he's just trying to protect his boss? Why? Well, he's in trouble. Yeah. Okay, they are still on break. Let's get back to Tuesday then, while we wait. Here it is. This is Tuesdays. This is Mr. Shard arguing about the Georgia Supreme Court decision regarding lyrics and music videos not being admissible in court without a 403 and cumulative. I mean, it's extremely narrow according to the Georgia Supreme Court. But the judge, well, judge is the judge. So let's listen to that.
You might have been involved in, not just, and I'm saying that nexus is something that is a little bit, Baker speaks to where the court's got to look at in footnote 16, that it's not like he's not involved in the video. He's prominently posting the video, and it's not like somebody else is attributing those statements to him. No. So, I mean, I think it's a little different.
Well, I disagree that it's relevant, but I will also talk about the probative value in a second. okay? To the extent there's probative value, because there also needs to be 403 balancing. I don't believe it's relevant, but we'll talk about the probative value.
Okay, but remember, in Baker, the person wasn't even in the video, right?
He was.
In Baker?
Yes, he wasn't the artist. I think the gentleman's name was No Cap, was the artist, Mr. Kobe Crawford. The gentleman, Mr. Baker, was in the video dancing with a firearm.
Yeah, I mean, but here's the thing about it, is, but that particular individual neither authored the lyrics or the views or values reflected in the video were adopted or shared by the appellant. So a little different. I mean, I think it's a little stronger in this particular video. I mean, and that's a jury's determination. This is just the court's threshold issue. But if I'm rapping about, I beat a murder rap, okay? That's pretty, I mean, the jury could consider that as a statement against interest, right?
No.
Okay, well, we're gonna disagree. We're gonna disagree about that.
So if I said,
well, it wouldn't be wise for one to say I beat a murder rap and the prosecution's still open.
Whether it was wise or not is a different issue. If he contacted me before
you probably would have told him, don't say that, right? Or don't write it.
That doesn't make it relevant.
Well, it's relevant for the jury to determine whether or not he committed a murder.
Saying that you were arrested and let's put context.
Okay, but remember, there's other linkage that has to go on with that.
Yeah, okay. We started off with this while we waited. And this is the Supreme Court decision to narrow the times when lyrics and music videos can be. And what the judge says here, more or less, is, well, if you are arrested for a crime, that can be brought in together with the music video as an admission of guilt. That's not, no, Your Honor. You need a trial and a conviction for that argument. But under the RICO charge as an underlying act, apparently it's allowed.
In Baker, it's a little different. The courts are kind of, telling us, look, you have to show some particular, nexus, and you have to make sure that,
like number 202.
I mean, they had beef in this particular case because it was minimally probative. Okay.
What is
in this particular circumstance? I think that they've tied, along with the client wearing red, client wearing YSL t-shirt, shirt, and then rapping with.
Exactly, AJ Tyler. There wasn't a conviction. It was dismissed. He was only charged. So if there's no conviction, there is no admission of guilt that has been proven in a court of law. You can't take that as face value, Your Honor. You shouldn't take that at face value.
Other arguably members of YSL about a potential crime that he may or may not involved in. Now, the jury can decide that that's not what it stands for, and they're going to weighing the evidence.
Your Honor.
Under 403 in Baker, the 11th Circuit, as Mr. Steele pointed out in Gamory, 635 F3rd 480. The rap video in this particular case was minimally probative under 403 because there was no proof that the appellant authored the lyrics or the views and values reflected in the video were in fact adopted or shared by the appellant.
Well, Gamory deals with a different set of facts, but just because my facts don't match Gamory doesn't mean the opposite conclusion.
No, but it tells me, it shows the probative value is stronger in involving your particular accused.
Okay.
And we may disagree with that. I'll have to see hear what the state says about it, but and that's subject also to foundation, but we'll see.
Fundamentally, Your Honor, I just don't, probative value, there has to be probative value towards a factic issue.
Yeah, but not your client committed murder.
But he doesn't admit to committing a murder. He talks about being arrested, and that is not an issue. He has been arrested. Nowhere does he say, I committed a murder on that video. If he said that, we'd be in a much different position. And he doesn't say that. And that's the whole point. All he's saying is I was arrested.
Well, it also depends upon what else the state has to proffer in regards to that. And I don't know what they have. So, I mean.
Okay, well.
So I mean, like I said, so like a lot of these lyrics and songs are subject. That's why under the
regarding
under 103, and I let them in preliminarily, subject to foundation. So, and I'm still going to do that with your client, and anybody else who's who may be featured in songs or videos. So
regarding the staying on the video, okay, and then I'd like to address the other the other video, the social media post as well. But staying on the video, if we were to agree that there's relevance of red YSL necklace and saying he was arrested, that is probative of something, then you have to get to the balancing. And it's prosecutorial need, overall similarity between the act, and temporal remoteness.
I'm just going to give you a heads up. You got about 10 minutes left, okay?
Okay. Well, so, Your Honor, regarding probative value and prosecutorial need, I'm going to read from Arrington v. State. and that is 355 Georgia Appeals 361, 2020.
357,
355 Georgia Appeals 361. And this is
351 Georgia Appeals, that what you said, 355.
355 Georgia
I'm sorry,
Appeals
thank you.
361.
All right, 361.
And
All
it's 2020 case. And on 364, it says probative value of evidence derives in large part from the extent to which the evidence tends to make the existence of a fact more or less probable. Generally speaking, the greater the tendency to make the existence of a fact more or less probable, the greater the probative value. And the extent to which evidence tends to make the existence of a fact more or less probable depends significantly on the quality of the evidence and the strength of its logical connection to the fact for which it is offered. Probative value also depends on the marginal worth of the evidence, how much it adds, in other words, to the other proof available to establish the fact for which it is offered. The stronger the other proof, the less marginal value of the evidence in question. And probative value depends as well on the need for the evidence. When the fact for which the evidence is offered is undisputed or not reasonably susceptible to dispute, the less the probative value of the evidence. So
Are you talking about 403?
yes, I'm talking about 403.
Remember in Arrington, that was a 404 determination because you have prior bad acts, right?
Right, but that's where,
So are you saying that then I should look at this for the 403 analysis?
403 analysis.
That's what this is giving?
In reality, that's where a lot of our 403 case law comes from, is 404B cases doing the 403 analysis. And the point I'm trying to make, and there's other cases that stand for this same proposition, but
It's a little different. You have to agree with, because in determining other acts, you got to look at, in probative value, you're looking at evidence offered to prove the intent includes its overall similarity to the charged crime, the prosecutorial need for it, its temporal remoteness. And so when you're talking about that, it's a little different in terms of probativeness. Wouldn't you agree?
well, I'm just focusing on the 403, which is the second prong of the 404B analysis.
Mhm.
And so I'm just isolating the 403 analysis. And Your Honor, merely what I'm saying is the state in their discovery has handed over social media posts, hundreds, maybe thousands, several social media posts with Shannon Stillwell on social media, with Slat, with Snakes, with Quindarius Zachary, with other people. If the whole point of this is he's wearing a YSL necklace and he's wearing red, if that's what this is really all about, A, they could just show a screenshot of wearing the YSL necklace and that would equally prove the point. B, they could show any of these other pieces of evidence shared to discovery. They have a plethora of evidence that they claim ties Mr. Stillwell to YSL and to Quindarius Zachary. So the video, the playing of this video and those rap lyrics, which talk about robbing drug dealers, which talk about carrying a stick, are it's completely unnecessary and it provides no marginal probative value because those same arguments can be proven through other means. And that's the whole point of that.
Is robbing the drug dealers and carrying a stick part of the homicide, the alleged homicide?
No.
Okay.
And and so danger of unfair prejudice, I think Mr. Steele talked about it, obviously references to robbery, and I think that's pretty self-explanatory. And essentially what it comes down to, the real value of this is not to show that there's a nexus, an evidentiary nexus to any of the offenses that Mr. Stillwell is charging, but the real value is it comes down to propensity, shows a violent disposition. And you know, there's several cases. I know I want to preserve some time. Strong v. State, 309, Georgia 295. Thompson v. State, 303, Georgia 533. Moon v. State, 312, Georgia 31. Arrington v. State, which I already cited. And all these cases come after the change in and again, a lot of 403 analysis comes under 404B in our case law, and it comes after the change in propensity no longer being a permissible use of 404B, and then a 403 analysis to find what non-propensity value does this evidence contain, and then weighing it against the danger of unfair prejudice. So now, Your Honor, regarding the other video, I just want to.
Now you have to point to which one you're talking about.
The one in the car.
Stillwell 1 or Stillwell 2?
Stillwell 2.
Okay. All right.
Okay, so I just wanted to read about unfair prejudice briefly. The term, this is from Baker, and it says, the term unfair prejudice, as it is used in 403, refers to the capacity of some concededly relevant evidence to lure the fact finder into declaring guilt on an improper basis rather than on proof specific to the offense charged. And that's citing the Old Chief of the United States, 519 U.S. 172. Generally, such improper bases for a finding of guilt include a criminal defendant's bad character or his propensity for violence. So,
But the lyrics in this case are not being offered to show propensity.
well, then let's redact them. Let's redact them. Then let's redact them. If that's not the point, let's take out references to robbery. Let's take out references to a stick, if it's that simple. But regarding this other video that I want to talk about, Your Honor, in Stillwell 2.
Got 3 minutes.
Okay, if you listen to the video, it's a express, I think it's an express statement to
I'm
a
playing this
popular
at
rapper known as
1.5
The Game.
speed.
His name is
You wonder why
Jason Taylor.
he's talking
I don't
that
know
much.
the backstory behind everything, but it includes words such as, this is what got Biggie and Tupac killed. If you come here, I'm at your neck. okay? The game, Jason Taylor,
Yeah. Today's hearing is on a brief break. So I'm going through Tuesday's motions hearing. And then when they come back from the break, we will go to today's hearing, because today's hearings is completely separate from Tuesday and Wednesday's hearings. When today's hearing is done, we will go back and listen through Tuesday and Wednesday, so I can try to interpret what is going on with you guys. Okay. So that is why we are playing Tuesdays at the moment.
is nowhere listed in this indictment as a victim or as a witness. Okay, there is no, and I'm not, maybe the state isn't planning on trying to introduce this. I don't know. All I know is it's provided in discovery. It has no direct link to any of the alleged crimes in this case. Again, it portrays Mr. Stillwell as a violent man, as a man who likes to settle his beefs violently, responds to violence. Strong v. State, 309 Georgia 295, prior bad act that shows propensity for controlling other people with violence and responding with violence when people don't submit, was too generic a motive and just bad character. So, and had very limited probative value compared to the great danger of unfair prejudice. Not only unfair prejudice, but a waste of time. And specifically in this case, when we're going to be dealing with the alleged shooting of a bus that another rapper known colloquially as Lil Wayne was on, it presents the possibility of confusion of the issues as well. There is nothing in this case that has anything to do factually with that video that depicts Mr. Stillwell and others, but it does.
All right, they are back from the break. So let's continue today's hearing. Yeah, we will continue with Tuesday and Wednesday once this hearing here is done. And later today at 9 p.m. Eastern, I will be joining Larry, the DUI guy plus, on his channel to talk about the Delphi case, which is another case I'm covering in a trial that is starting May 13th, where the judge is, this might be hard to believe, who is even worse than this one. It seems like most cases I cover is with incompetent judges. That's weird. Seems to be a pattern with elected judges. Yeah, we are $15 in super chats, gift donations, or via PayPal, or buy me a coffee. From a spin of the Wheel of Regret. If you wonder what spin of Wheel of Regrets is, it's this one with hot sauce, gin shot, whiskey shot, a clove of garlic. Yeah, some good stuff, some nasty stuff. Yeah, I will do strange things for money. I mean, $50 is $50.
Mr. Yahelski, we'll be able to parse out as it pertains to the state's exhibits.
All right, I was able to get some clarity on the two issues we left off on, starting with, I can emphatically state in my place that Ms. Love was never alone with Ms. Bennett for any oral conversations. With
respect to the bench conversation.
Yes.
Outside courtroom bench conversation.
Yes, and that one, and I'll clarify that. It started out with Ms. Love and Antonio Long, and then there was.
I don't believe you. Whoever this junior prosecutor is, I don't believe you. I really don't. I think you are stating things you cannot prove. I think he's lying to the court. Now, this might be because Miss Love told him, oh, there was always somebody around. Okay, then I will assert that to the court. I don't trust Miss Love either. How's that? because she's been unethical this whole time.
Was this a representation from AB about harming herself due to the fact that, the state wants her to testify, by the way. But after that point, Adrian was sort of backed off, and then Tamika Kelly and Partrina Baker then went ahead and got with Miss AB at that time. And I will say, if Your Honor thinks that cross-examining AB on that conversation is
You're
not
talking about
enough.
Ms. Bennett.
Yes, sir.
Okay, all right.
If Your Honor thinks that the defense cross-examining AB on that conversation and the circumstances surrounding it and everything about it is somehow not enough under the Constitution, then you have those additional witnesses. The next part is the text message conversations, okay? I wouldn't even call them conversations, but they're
Okay,
contained.
let's the first, Grant, tell me which text message conversations, because I want to say there's 32, 33, and 34 alpha. Is that correct?
Yeah, 35 alpha.
Oh, and 35, is it started at 33 or 32? Yeah, you all have them, so I don't, so.
Well, the ones that pertain to Ms. Love's conversations, the text communications, are 35 alpha.
Okay, so let's take a look at those.
And so when you do take a look at those, and I'm looking at them now, I'll just characterize them. They're sort of pleasantries. How are you doing? Good morning, et cetera. I mean, we can take a look at every word of them. And like I said, they speak for themselves.
Let
And
me
again,
take a look at 35
sir.
alpha.
and their approach.
Yes, you may. Thank you.
I'll give Your Honor some time to look at those, but I'll be ready to continue at the court's pleasure.
Yeah, but here's the thing. These are the claims this junior prosecutor is doing. There needs to be an affidavit to it, at least, and I still don't believe it. But the judge found a loophole, I guess. It shouldn't be there. His only two options.
Okay, all right.
So what I would say,
The judge's only two options here should be mistrial or removing Ms. Love from the prosecution's bench by making her a witness. That should be the two only remedies here. It's unforced error, in my opinion. And that is a clear appellate issue. If concluded by the appellate court that, yeah, then all of this was for nothing. So the easiest path for this judge would be to say, Ms. Love, you are now a witness. Because the judge is risking this entire trial on Ms. Love's unethical conduct.
about those text messages, Your Honor, as you look at them, they're pleasantries, they're administrative, they're collateral. And the larger points, one of the larger points is that these are just text messages that Ms. Love sent to AB as part of, we want you to testify, we're, using you in the case. For the most part, AB doesn't really say anything except for those two instances, and those are administrative responses in the first place. And even more than that, the idea that a prosecutor texting a witness about coming in to testify and how are you doing and all this other stuff,
It's not
that's just text messages that occurred between Ms. Love and AB. That's not unsworn.
The defense the defense are not arguing the text messages. They are arguing about her making herself a witness by referring to conversations she had with Miss Bennett, not the text messages. And in case of the text message, if Miss Love asserted one thing and the text says different, then she is also forced to testify. Why did she misrepresent those text messages to the court?
Testimony. And when it comes to the ability of the defense and the right of the defense to impeach on matters like that, Your Honor, I want to point you emphatically to Scott v. State. Okay, that's a 2020 Georgia Supreme Court decision, 309 Georgia 764. And again, that's 309 Georgia 764 at 770. And it says as follows. Under OCGA 24-6-621, a witness may be impeached by disproving the facts testified to by the witness. But this statutory provision does not provide a party with an unlimited ability to impeach a witness by contradiction. To use an example of something that did come out maybe in testimony, isn't it true you were late to the meeting? Okay, yes, no, it doesn't matter what the answer is, it's collateral. Scott says a party may not use extrinsic evidence to impeach a witness by contradiction on a matter collateral to the material issues at trial. Whether AB was late to the meeting, not material to the trial. It goes on to say that even under the former rule that preceded 621, a witness may not be impeached based upon a discrepancy relating to a wholly immaterial matter. And even further in Scott, going on to 771.
If it's not a material matter, then it's irrelevant and should be stricken in its totality.
It talks about how the person's the ability to disprove something that's relevant to credibility, that a discrepancy on that point does not relate to a material issue in the case. So I'm going to leave the court with Scott. I'm going to leave the court with my understanding of the extent of the text communications that would have just been between AB and Ms. Love. But I want to leave the court with the final impression, again, reiterating that those text messages are not testimony. And really, if the defense wants to talk about them, they could ask Ms. Bennett. And so we would ask the court to deny this motion.
All right. One more thing. Do you all have a copy of the affidavit for the material witness warrant? I'd have to do an order unsealing it.
We can provide. We can certainly.
Do you have a
provide
copy of it with you, or do you have? Can you get me a copy as I collect?
We'll provide a copy to the court immediately.
Can you all give me one in the next 5 minutes?
Listen to the defense replying to this kind of garbage.
Okay.
The
All right.
prosecution.
So I want to take a look at it, and
forward.
I may, depending upon what it says, make some other additional findings. Okay.
All right. Thank you, Your Honor.
So I'm just going to recess in place.
No, you need to listen to Jesus Christ, Your Honor. Motion, reply again. This is Jesus fucking Christ, Your Honor. The defense have a right, or should have the right, to rebut the prosecution's claims here. This is so incredibly stupid. And they're on a break again. This is so infuriating, watching this judge making a conscious effort to avoid clear violation of statute, of ethics codes, and the bar code. All right, while we wait, let's go back to Tuesdays. Dun, dun, dun. While we wait. Yeah, I know, jumping back and forth might be a bit, but...
Factually, with that video that depicts Mr. Stillwell and others, but it does have great danger for unfair prejudice. It will encourage jurors to determine guilt based on those concerns that I read about from the Baker case, that I quoted from the Baker case. And for that reason, that fails the 403 balancing test, the danger of unfair prejudice. And
this is the judge going against Georgia Supreme
substantially
Court
outweighs any probative value, which is none in that video. We believe also, going back to the rap video, respectfully, Your Honor, that the Stillwell one, that the scant probative value that Your Honor identifies in that video, that I respectfully disagree with, but the scant probative value is substantially outweighed with the danger of unfair prejudice in that video. And so for those reasons, we would ask that Your Honor rule both videos inadmissible in this trial. Thank you.
All right, thank you, sir. All right, who's going to argue for the state? All right.
Okay, we are there's 280 of you here. Thank you so much. That's a great number for my little channel. And we have 214 likes. Could we get to 250? Could we get to? I think we can do it. Come on, folks. You can do it. Oh, let's see here. Daily quick bites. That says that's another thing. Apply. Although it doesn't apply with these defendants. Judges here often ignore higher authority when they know the defendants can't afford appeals. Yeah, this is not the case here. These defendants can afford an appeal. And this is an issue when you don't have money for it. For instance, in the Zachariah Anderson case, where they are, where I am occasionally doing fundraisers for for his appeal, he is currently, in my opinion, wrongfully convicted, and an appeal to the appellate court goes for around $250,000. That's the cost. Now you can get a public defender doing the bare minimum for an appeal. Oh, they seem to be back here. Yeah, so, okay.
It's too loud.
I heard sound from today. Yeah, so getting an appeal in the United States is expensive just to get the bare minimum to the appellate court. Over here, we have a different system. Here, your right to defense. The courts here in Sweden is a separate entity, which is good. The prosecution's office is separate from the court, so they get one budget. The court's budget includes the budget for the defense attorneys. Now, an accused can be ordered to pay attorney's fees, but until that point in criminal matters, the court pays the defense attorneys. So you don't have to pay for your own defense until a court says you have to pay attorney's fees. I believe that system is better, but I do believe in general the United States court system is better in many other forms, especially when it comes to charges and stuff like that. For instance, in the United States, you really can't, well, they still do, jail people before there is an actual charge. I mean, in Fulton County, we know that up until the end of the year, of last year, there are 307 people in Fulton County Jail who has been unindicted for more than 6 months. There's a guy who was incarcerated in jail for 434 days, and then he was acquitted. 434 days, a year and a half, well, a year and some months in jail, unindicted. That's insanity. Okay, I thought they were back. Apparently they're not. Dun, dun, dun. What else can we do? Let's check the likes count. We are up to 222, 224. We can get to 250, I think. I think we can get there. I think we can get there. Let's see here. Well, while we wait, we can listen to the state's reply to the motion regarding the Georgia Supreme Court's decision regarding lyrics and videos not generally be admitted as evidence without a proper 403 hearing. While we wait.
All right, I got a half hour.
I already started the timer, sir.
So the broader realization I'm having as I'm hearing these defense arguments, Your Honor, is that this Baker case came out, and it's a case that applies 403, but it doesn't change the law on 403. I think we're getting arguments that sound similar to the idea that, you know, Baker came out and there's this case where a rap video was excluded. So therefore, that's now a change in the law. That means all rap type evidence is now radioactive under 403. That's a flawed proposition, as I'm going to get into. So I'm going to start with Mr. Williams' arguments, and then I'm going to try to get into Mr.
Nana Misty gifted 5 memberships. Thank you so much. It went to Louis Thomas, Daily Quick Bites, Knock It Offler, OBCNB, and I Am Shout. Thank you so much. And that, ladies and gentlemen, bring us to the Wheel of Regrets. You just got us to a combined $50 in gifted memberships. So here we go. A spin on the wheel. Let's see where we end up. Oh, fuck. That's the hardest sauce I have. I'll need to get myself a spoon. I'll be right back. Darn it. Yeah. Do I regret this? Yeah, already. All right. Shaky, 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 shaky. Inferno sauce with scorpion maruga. Jesus. Jesus. Hiding that choice. All right. They are back. All right, let's continue with today's hearing.
Why don't you come to the podium?
Yeah.
Thank you.
I believe this is what the court's going to do, but we just wanted to make sure that we redact and make sure that it doesn't come out to the public, any of this biographical information, you know, date of birth, address, stuff like that, if that makes sense.
I think that could be arranged.
Sure.
Mr. Steele, what I'm going to do is I'll redact out the biographical data of the witness.
No opposition.
Okay.
Okay,
All right.
thank you.
All right, so we'll just do that before, when I unseal it, okay?
Thank you, Your Honor.
Okay, all right. Christina, can I see 34 and 30? Yeah.
Yeah, that cleared up the sinuses. Hey, legal vices. Hey, I'm going to send Jeff a link. Dun, dun, dun. Welcome, legal vices, from Legal Vices. We are currently, and have been for 2.5 hours, watching a hearing about disqualifying prosecutor Love because she made herself an unsworn witness. Now, how do you do that? Well, you go to the podium and you ask a witness on rebuttal stuff like, when we spoke and I said this, didn't you reply this? And did that for roughly 20 minutes. That is, in my opinion, an unforced error and makes her an actual witness. Now, this judge is who he is, trying to find every loophole in the book. And it seems like the prosecution has offered, well, there was witnesses to this. We promise there were witnesses to all of these conversations, the prosecutor. So let's have people she hired and have them testify on her behalf, or well, testify that they were there listening. That would not be admissible in Swedish court because they are in reliance of Miss Love for their employment. Over here, if a certain someone is a part or made themselves a part in a trial, they have to testify to it. They can't say, well, he listened, he heard it, he can testify. Well, that is hearsay. So I don't understand how this judge always finds an improper loophole. So if you go back about 90 minutes, I guess, you can hear all of the shenanigans that the prosecution in this motion to disqualify Miss Love. And well, thank you all for being here. Hit the like button. You just arrived from Legal Vices. You know how to do it. It's just down there somewhere, and you press the thumbs up. Jumping ahead, because silent moments. Jesus Christ, George. This shouldn't be this hard. It's only this hard and takes him this long to come to a conclusion because he's so actively looking for loopholes. For you who don't know, the prosecutor making herself an unsworn witness is an unforced error. That should be the end of the debate. And the defense cited more or less 90% of the circuit courts and the Supreme Court and the Georgia Supreme Court and local courts' decisions. But this judge still tries to find this damn loophole. And if I read this correctly, he will find this loophole by making Miss Love's subordinates testify that they were witnesses to this conversation. Why do they want to disqualify? Because Ms. Love made herself a witness, a material witness in this trial. There's no way for the defense to find out what was, because she asked a series of questions to a witness where she interjected herself and supposed communications she had with the witness. The prosecution argues that, well, they can cross-examine the witness about it. And that's not correct, because it was Ms. Love who made statements of what she said in a conversation. Then she is the proper witness for this.
In a position to give you my thoughts on ruling on this particular issue. The court has considered the issues framed in the defendant Williams' motion to enforce the disqualification of prosecutor Love. And to that end, I've considered what has been pled in Mr. Williams' motion. I've also considered the state's response to defendant motions, defendant Jeffrey Williams' April 1st, 2024 motion to disqualify. I've also considered the arguments of counsel. I've also taken into account and will take judicial notice of the proceedings to include the transcript of proceedings on, and in particular, 28 and 29 March of 2024. And the court also has had the opportunity to review and consider the following exhibits. States 32 alpha alpha, states 33 alpha alpha, states 34 alpha alpha, and states 35 alpha alpha. In considering these motions, the court has also considered the defense's three groupings of the examination of Ms. Bennett as it pertains to their assertion that Ms. Love has inserted herself and become an unofficial witness. In regards to this, I have also considered and will consider for purposes of the motion the statements that were made in court on the 28th and 29th of March, even though video was shown to the court. In regards to those, the official transcript will be the record that the court considers. I've also considered the communications between Ms. Bennett, the witness, and purported to be Ms. Love and other members of the staff of the district attorney's office. And then third group of consideration is the communication by telephone at various times between Ms. Love and Ms. Bennett in states 35 alpha alpha. In considering those, the court has also taken a look at the cases that both the state as well as the defense has proffered and invited the court's attention in respect to this issue of Ms. Love and being an unofficial witness. The court is of note considered Bonner, as well as, and Bonner's at 192 Georgia Appeals 721. And also the court has also considered Cantwell versus Kent, 254 Georgia at 556, and Scott versus the state 301 Georgia at 764.
Supreme Court as well, Your Honor.
And
And the other circuit courts.
24-6-621, as well as the Georgia Rules of Professional Responsibility.
Yeah, that as well. I mean, the rules are clear, in my opinion. Come on, Judge. All the other circuit courts. The Georgia Supreme Court decision relied on other
3.7.
states' decisions. So you can too.
To the defense's arguments and assertion in the first grouping that has been brought to the court's attention on March the 28th and March the 29th of 2024, the court has heard some concerns from Mr. Steele saying that those conversations could not be challenged by any other examination than Ms. Love, and has thus asked the court to disqualify her. The court has considered that particular request, and in regards to the colloquy that that is had between Ms. Love and Ms. Bennett, as referenced from the transcript, in the interest of fairness and judicial economy and clarity, the court will unseal the affidavit as it pertains to the material witness warrant that the state sought to comply with Ms. To help to facilitate Ms. Bennett's complying with being here as a witness. I will make that available immediately. I will do two things. I will sign an order unsealing that particular affidavit. I will also block out the proprietary information as it relates to Ms. Bennett from that. But Mr. Steele and Mr. Uhelski, I will make the balance of the affidavit in its entirety available, and I believe that that will also provide you with information as to others that may satisfy your concerns and respect to that issue. The second area of communications from the courtroom bench outside the courtroom as it pertains to Ms. Love. I believe that Mr. Uhelski is proffered and stayed in his place, that Chief Investigator Long would be the person, as well as the two victim advocates that can provide information in respect to any communications that need to be tested or heard of during that particular period as it relates to that issue. And then thirdly, the communications by telephone at various times in states 35 Alpha as it relates to Ms. Love and the witness, Ms. Bennett. The court in reviewing those doesn't find anything that would be other than the one advocate's attempts to seek scheduling and pleasantries with the witness. And for those reasons and applying Bonner and the other cases that the court has cited for purposes of this analysis, I'm going to deny the defense's motion to disqualify Ms. Love. I will also, though, as a caveat to all counsel, just invite you all to just be mindful of witness interviews and the importance of third parties being present for the reasons that our professional code of responsibility tells us. So we don't inadvertently make ourselves as lawyer as witness. So with that, that's the court's ruling. Mr. Uhelski, if you will prepare a suitable order for the court's consideration, send that to Mr. Steele. And if I could get that by next Friday, that would be the 12th of April. That would be fabulous. Okay? All right.
Your Honor,
Yes, Mr. Sharp.
as Mr. Steele, I believe, was the only signatory of the motion and did the arguing. I just want to ensure for the record that the Harvey rule is still in effect. And
It applies to all. So,
thank you.
Yes.
Yeah, this is infuriating, but expected, because this judge, in my opinion, is just a part of the prosecution. Is a spineless coward who refuses to apply correct law, and now he refuses to apply the ethics code and the bar rules to this, allowing the prosecutor to insert her opinions into record about statements she made to a material witness. Ronan Warhite, did I hear that correctly? Is his name Mr. Short? No, SHARARDT, Shardet. It's unfortunate, but yeah. So yeah, in my opinion, this judge and here's the thing, when he makes these rulings, other courts will make the same rulings. And you heard him saying to the people, be aware of the ethics codes and stuff like that. If, Your Honor, if your ruling is correct, then you didn't have to make that comment. You know you did wrong here, Your Honor. You know, but you do it anyway because you're a spineless coward. Hello, Tracy Fagan. Thank you for your $2. For the record, are you objection? Preserve the record. Yeah. Now this, in my opinion, will be a reversible error. Could be. But it is a strong candidate for an appellate court to simply look at it and says, oh, hell no. But you never know. He's the chief judge, and judges sometimes like to back each other up.
Okay. All right. One other thing, Wes.
Exactly. Why would they care about ethics if they know they can get away with violating them? Yeah. Now this judge has moved the goalposts so far off field that the prosecution can do basically anything in this trial, because the judge showed again and again and again he is prepared not only to move the goalposts, he's prepared to burn it down in favor of the prosecution. Now, once this hearing is done, we will go back and listen to Tuesday and Wednesday's hearing, where the judge violates a Georgia Supreme Court decision. That will be fun. Let's see here, speeding ahead. Oh, for frick's sake, Judge. So we have, when we get to Tuesday and Wednesday, we have roughly an hour and a half to go through combined. I hope you will stick around for that one. And I also hope you give me all the likes and all the subscriptions. If you haven't subscribed yet, please do so. This stream is not monetized while I am live. It will be monetized, or I will attempt to monetize it once for the replay crew. So they will get, maybe for a 4-hour content, they might get 4 or 5 ads. That brings a few bucks in. Let's see here. Oh, for you who don't know, we are currently $48 away from the next spin of the Wheel of Regrets. Yeah, $50 gives you a spin on the Wheel of Regrets. I already spun it once, and it got on Scorpion sauce, which is the hottest sauce I have currently. It's Scorpion Maruga based sauce, and it causes hiccups and stuff. And it cleared my sinuses. But we are waiting for the judge to actually adjourn. Let's answer some few. Daniel Santiago, this is an appeal distance of mistrial. Well, the judge should have had 2 options here: removing Miss Love or deeming it an unforced error and mistrial with prejudice. That was his 2 only options, in my opinion. But he found, or he made himself a loophole that shouldn't exist. In order to protect the prosecutor Love, he is allowing in hearsay from her subordinates to cover her ass. And that's Jesus Christ. No, that's not Tracy. Is that the defense? No, that is his clerk of sorts. So this is not.
Okay, all right. I don't think I have anything else I need to add or with you all, other than
if you want to receive gifted memberships, click on the $sign at the far right of the chat bar, keep membership,
other
and
than
click on the three vertical
we'll be
dots on the right
back in
and turn on
session
allow
at
gift.
8:45 on Monday morning. I'll cover with you all my administrative order, and just to make sure it'll be entered and all of you will get a copy of it. Okay, anything else? Mr. Harvey.
If one logistical matter, if we are to be here pursuant to your 8:45 requests, we need a current order to get us in before 8:30 so we can be here, be ready to go per your 8:45 requirements. If your staff can prepare us an order allowing us to get in before 8:30, we would appreciate it.
Mr. Harvey, I will take care of that momentarily, okay? All right? Okay. Anything else?
Wasn't Ms. Love supposed to have a list ready today? That was yesterday, and she handed it over. We will go through this. Once this is done, we will go through Tuesday and Wednesday. It's about 90 minutes compressed, so we will get through it. So we will get there, the list of witnesses that the judge forced them to trim down more, and they did, and then they added to it again.
The 8th, and what we like to so the Love is she consistent with my orders. So unless there's anything else, I'll see you all on Monday, okay? All right.
All right. That was the, in my opinion, absolute cluster F from the judge. It was expected, but I didn't expect it to be so blatantly. I thought he would let the prosecution create the loophole and him applying it some way. In this case, he created the loophole, allowed the prosecution to amend their reply to fit that loophole. He created it he made himself the prosecution again. But let's go back to Tuesday. They are still arguing the Georgia Supreme Court decision to, it's a 403, which is how to admit evidence. And it's about lyrics and music videos. And the Georgia Supreme Court was very clear that music videos and lyrics, if you want that as evidence, there has to be a nexus to it. The lyrics must more or less be, I did this and that to conduct this and that person saw it and that person was this. Then it can be used as evidence. This judge doesn't care. And yeah. And yes, I was expecting to see Miss Willis or District Attorney Fani Willis here today in court to argue because she wrote the reply. But she's a spineless coward, a harlot, and a cheat and a liar. So, of course, she didn't show up and let a junior prosecutor handle it for her. But let's get on with this.
Wells arguments in a little bit more specific, and I may refer to my colleagues when it comes to
I'm playing this in
granularity,
1.5
but I
to
just wanted to
compress
provide
it
an
all.
outline of our thoughts on the law here. So Baker it's being touted as though it kind of automatically operates to vacate this court's lyrics order from November. That's not the case. It doesn't suggest that. It certainly doesn't compel that. I want to start with the fact that Baker is a 403 case. And as such, it's a limited fact-specific holding. We know that the court and all the parties have read Baker, but just to reiterate, the sole enumeration of error in Baker was the trial court abused 403 in letting this video in, okay? So there was a pretrial motion in limine to exclude specifically this video, by the way, a particularized pretrial motion. And then the trial court's order denying that motion said, oh yeah, it's relevant for identity, and it's relevant to show his relationship to this other guy, who's an unindicted third party, by the way. So with really no explanation, the trial court just said, yeah, it passes 403. And then there you have it, it gets in. Notably, as pointed out by my colleagues, Baker's identity at the nightclub where the incident happened was absolutely uncontested at trial. Further, Baker's relationship with his tour manager, which he had known since childhood, was also totally undisputed, and it wasn't even a material issue in this single defendant murder trial. Okay, that's a big difference between the charging posture of that case and the case here. So given all that, it's pretty easy to see how the Supreme Court said, yeah, it doesn't really have any probative value. It's a murder case, and they're throwing in this rap video that was filmed, I don't know, several months before that's got nothing to do with the murder. Highly, wildly distinguishable from the facts in our case. So the video, like there's nothing really in the video connecting the guy to the murder. But meanwhile, what it does show, and what my colleagues have pointed out, was that it does show Baker dancing and brandishing a semi-automatic pistol with apparently an extended magazine, and he's pointing it at the camera, at the jurors when they watch the video, and they watch it 3 times, okay? The prosecution, our colleagues over in Houston County, they made hay with this video, okay? They played it 3 times. They played it once during the lead detective's direct. The suggestion was that, you know, this is a violent gunman. They played it again during cross-examination when Baker took the stand to kind of confront the idea like, oh, well, why would I have guns around? No, this is why, because look at this video. You're a violent gunman. So they're reinforcing this propensity argument in Baker, and then they really nail it to the wall in closing in Baker, where they just drive it home that not only is Baker have this propensity to commit gun violence, but he has this propensity to promote it and glorify it in this video. And it became a central focus of the case. I mean, that's right at page 32 in Baker. It was proof essentially of nothing, Your Honor, and it became a central focus of the case in Baker. And so when you talk about, you know, the idea that 403 contemplates that you can look at a piece of evidence and kind of look at his tendency to lure the fact finder into declaring guilt on an improper basis, it's absolutely, I mean, the Supreme Court had to conclude what it did about the video on Baker.
Because of their use of the video.
Exactly. And because of the fact that it had really nothing, it proved nothing that was at issue. So it had zero probative value, and it had whatever prejudice was inherent in the imagery, it multiplied it by 3, and they made absolute hay of it in closing and throughout cross and during direct.
And what do you do with the videos and lyrics? You had Miss Love read lyrics with her own emphasis to the jury. And the judge didn't allow, through the rule of completeness, the defense to counter it with playing the actual video. Then it was okay to exclude the video. But when the prosecution wants to play parts of video, he's allowing it. And that goes against, in my opinion, the Georgia Supreme Court ruling.
I also want to point out another very important difference. Well, I'll get to that later. I guess I want to just say, look, this case, Baker, it doesn't change 403. It's an example, you know, the court should consider it. And really, the court's lyrics order leaves open at trial objections under 403. So Baker leaves the court's lyrics order undisturbed. That's the headline here. The court's lyrics order is kind of like a, you know, it's pretty robust. It was pretty assiduously researched, and it accounted for stuff like this. And it left open, as Your Honor is aware, foundation and 403 objections and further findings possibly at trial, if and when such evidence is going to be admitted. So to go ahead and say it undoes the whole lyrics order or any part of it, that is not correct. Everybody has their 403 objections. To say that Baker automatically excludes any and all the state's requested evidence under the lyrics order, it's too much. I want to remind this court that, you know, as everyone knows, 403 is an extraordinary remedy to be used only sparingly.
DJ Black Charm Music says, Nick, my man, I think these guys just have to hope to win an appeal. That's probably, that might be the case. My hope is that the jury sees through all of this garbage, takes 45 minutes after everything is concluded to just write down not guilty on everything, just to place a foot in the arse on the prosecution and this judge. That's my hope. Will it happen? I don't know. I mean, even in the clearest cases, there's still a chance of conviction because people are prone to convict.
Okay, this is not a blanket thing that we're going to use to exclude all categories of evidence that fall under, you know, rap videos, right? And then also I thought, which was interesting, is a Georgia Court of Appeals decision that came out March 14 of this year. It's going to be Anderson v. State, And the Lexus site is going to be 2024 Georgia Appellate Lexus 127. And that's at 8, and it's footnote 3. And it says something that I had actually seen it put this way, but it says the prejudice referred to in Rule 403 addresses prejudice to the integrity of the trial process, not prejudice to a particular party or witness. The reason they want to keep all this stuff out is, yes, prejudicial, but they're arguing that it's not relevant. They wouldn't be arguing to keep it out if it weren't relevant. It is relevant. Under 401 and 402, we're already there. So for that reason, I think that the limited nature of Baker as a 403 holding, Your Honor, follow the law to the extent that these my colleagues' motions are consider Baker. We agree, consider Baker, right? But don't vacate your order and don't alter the order. It stays the same. Now, Baker, as Your Honor is also aware, is highly distinguishable. Again, there was a pretrial particularized motion to exclude a specific video called Ghetto Angels under Rule 403. Whereas to date, at least from Mr. Williams, we have no particularized challenge to any of the lyrics that were previously admitted by way of this court's order. We have sweeping pronouncements about criminalizing art, generic invocations of 403, 404, but really there's no specific lyric that Williams has pointed to that is attributable to him that he finds objectionable, or at least he hasn't made any argument as to any specific lyrics why they should be excluded under Rule 403. But I didn't hear one. I didn't see one in the motion. I didn't hear one argued before Your Honor today. And highly important in Baker, the video had some disturbing imagery, et cetera, but the lyrics were explicitly not at issue. It's not a lyrics decision, Your Honor. It's a 403 decision on imagery. It literally says on page 18, footnote 13, the lyrics have no bearing on our conclusion that the rap music video was improperly admitted. That is highly important. I didn't hear any defense address that. Because in this case, the lyrics as statements, by the way, they're not just songs, they're statements. And they're statements by parties in this case. But the lyrics are exactly what was issued, and Your Honor already correctly ruled on the same, okay? We ruled on them as admissions of a party opponent under 801 D2A. John Floyd came down here, Mike Carlson came down here, Deputy District Attorney Hilton, we put on a heck of a proffer. It went for hours, okay? We put them in as adoptive admissions under 801 D2B. They came in under co-conspirator admissions under 801 D2E, statements against interest under 804 B3. And in Baker, they're not talking about 801 at all because the words, the statements, the lyrics were indecipherable.
Reformed convict says the judge forcing some of his lawyers that are being public defenders and not allowing them to only work on this case when they're only paid $15,000 for it and they're not giving them a chance. Well, there has been remedied during the during this trial. The one remaining lawyer, who is a public defender, has had a pay increase to, I believe, $5,000 a month or $6,000 a month, something of the sort. Which gives her $60,000 per year. Now that was amended by the judge because she was only paid, the contract was excruciating. It was so poorly written that it could be construed that she will be paid $5,000 a month up to $55,000 a month in grand total. So he had them amend that to pay her $5,000 a month per up to $60,000 per year. And this will be continued. Here's the thing. For all the work that she has to do, that's a drop in the ocean. All while this prosecution teams at the baseline is paid in excess of over $100,000 a year. But yeah,
they were not reached. The court made no pronouncement on the prejudicial, if any, effect of the lyrics because they just weren't heard. So it's not a lyrics decision. That's extremely important. And admissions, and this goes to Mr. Shart's arguments as well, but when you have party admissions, and we're talking about like a video where we have Stillwell saying the words. You can see him saying these words. I just beat a murder rap. I paid my lawyer $30 for that. Me and my signs above the law. And we're told that that has no relevance to a charge count in this indictment and to overt acts under the RICO count 1 of this indictment. It's a little bit of to me, it's a stretch. But the fact that the Supreme Court in Baker didn't.
Tracy Fagan asked, can you appeal during a trial? Generally, no. But certain decisions by the judge can be appealed. But that is on the discretion of the judge to allow that to go to the appellate court. And so far, this judge hasn't allowed any of these appeals to move forward.
Consider the lyrics at all, let alone analyze them under 801, makes this case in a different universe than the lyrics we have here, because it's just not talking about statements. It's not a statements case. And then lastly, a big difference that I noticed in Baker is that it's, again, it's a single defendant murder trial, whereas here we got a multi-defendant RICO and Gang Act prosecution. Williams' motion says, oh, it's no difference that he's charged under RICO and Gang Act. It makes all the difference in the world. All of the things being equal, in a single defendant murder trial, it's not necessary or material for the prosecution to show relationships or associations, like they tried to in Baker with the guy's tour manager, like that made any difference. And it certainly wasn't required even under the facts of Baker because his association was totally undisputed. So again, the probative value was nothing there. Here, by contrast, and which is consistent with this court's lyrics order, the relationship between and among these co-defendants, as well as their association with the alleged YSL street gang and criminal enterprise, those are crucial. In specific, because the defendants categorically have denied that YSL is either of those things. They've denied that it's a street gang. They've denied that it's a criminal enterprise. So the prosecutorial need to show that is absolutely not minimal or low, as argued by my colleagues. It's extremely crucial in this case in light of those denials. So the lyrics evidence in this case, already properly admitted, relates to, just as a reminder, the nature and existence of the alleged criminal enterprise / gang, the affiliations with the alleged criminal enterprise and gang, participation in the alleged criminal enterprise and gang association and membership, participation, and the connection of the defendants with one another. You can look at your order. It's at page 19, 24, 26, and 37 through 42. Those were already all found to be permissible purposes for the lyrics evidence in this case. So for that reason, Williams' motion should not be.
There she is. I'm skipping ahead now because this is just more of the same prosecution's garbage. So I'm going to skip a bit here, a long bit, to what the judge says.
The court. I understand your clients have had the opportunity to have lunch, so that's what we also delayed for a little bit. All right. The court's had an opportunity to consider Mr. Williams' supplemental motion limiting number 2, motion to strike, filed on 3/6 of 2024, which also includes a copy of recently decided cases the court mentioned earlier by our Supreme Court of Georgia, Baker versus the state, decided March the 5th of 2024, S23 Alpha 0860.
Tomorrow I started reading the Baker decision last week. I will continue that tomorrow if my voice holds up for it.
Related to that particular case as well, the court is also considering Shannon Stillwell's motions, 1, to exclude irrelevant and prejudicial audio and video evidence, and then supplementing that, or in addition, motion limiting or motion to strike regarding song lyrics. To that extent, the court has admitted for the purpose of the motion Stillwell's 1 and 2, which are videos that he wished the court to consider excluding for those particular propositions, both in the motion to exclude and then, which was filed on Stillwell 3/25/24, and then motion limiting motion to strike filed on 4/1 of 2024. The court will also admit for purposes of this particular hearing and for purposes of the record, and take judicial notice of the court's order entered on May the 27th of 2023, order granting the state's motions in limine to admit evidence of lyrics at trial and deny defense motions to exclude lyric evidence at trial. I will
Oh,
include it
he's
as the next
ignoring
court
the
exhibit in
Georgia
order for
Supreme
purposes of
Court
this particular
ruling.
motion, a 43-page order. Chris, I've already sent you a copy of that. All right, so, and also, the courts considered the state's response to defendant Jeffrey Williams' March the 6th of 2024 supplement to motion in limine number 2 and motion to strike. Motions, the court rules as follows. It is the court's opinion that the defense's reliance on Baker is in fact is also limiting and is fact specific and in regards to the facts of this case at hand. In Baker, the enumeration of error was the trial court abused its discretion of 403. In particular, the court failed to do a 403 analysis, and much differently than this court's analysis, this court did a fairly exhaustive analysis as is contained in its order
Buckled for the prosecution
of 11/27/2023.
Yeah, so that was the judge ignoring Georgia Supreme Court. If he can find loopholes, he will use it. If there are no loopholes, he will create it for the prosecution. This, we already heard it on today's motion to disqualify, and this is him ignoring Georgia Supreme Court decision. So let's get ahead to the next set of motions.
Sure. First order of business, Mr. Uhelski, if it's your task of preparing the suitable order on behalf of the state, is it?
It is.
Okay, 12 April. That's when you have to file a suitable order and send it to your colleagues for my consideration on the motions in limine, motion to strike, in regards to Mr. Stillwell and his motion to exclude irrelevant and prejudicial audio and video, and Mr. Williams' amended motion, limiting motion to strike number 2.
Hey, Hippo Press 365 Content 100. You stated yesterday that he would find a loophole. Yeah. It's sad how predictable this judge is. It's so sad. The length he's prepared to go to ignoring Georgia Supreme Court, finding and creating loopholes. Finding and creating loopholes against Ms. Love's misconduct in the courtroom. It's appalling. He's not doing his job. He's there. He should be a neutral part, listening to the defense, listening to the state, and then make a ruling. Instead, he argues on behalf of the state all the time, creating loopholes for himself. It's appalling.
All right, sir? Okay. All right. I am in possession of Mr. Williams' motion to enforce disqualification that was made orally last week by Mr. Steele, filed on yesterday evening. Ms. Love, if you could you and your team or the state file a response no later than by 5 o'clock on the 3rd of April, and I will take up.
This is him referencing the motion to disqualify we just went through. And I hate to repeat myself, but he made the loopholes, created the loopholes, and the prosecution all just had to argue the loopholes the judge created for himself. Judo Frank, what's the loophole? I don't follow. Well, the loophole he created for himself was allowing Ms. Love's employees to testify that they heard the conversations she referenced in her rebuttal of Miss Bennett. So what this judge is doing is creating a hearsay loophole to avoid disqualifying Miss Love because she made herself a witness. That's the loophole he created for himself, which is astonishingly bad. But I mean, I've been covering this case since May of last year, and it is bad. It's incomprehensible. I mean, it's beyond reason.
That motion at 9:30 on April the 4th.
Yes, Your Honor.
I will hear argument on that motion.
Yes, Your Honor.
You know, the court, like you have Mr. Kearns, I won't get a copy of it. You can do that, or my preferred ask is that you just send me a copy of whatever it is. Okay, so if we have to argue a motion and I've told you to take it up, please just make sure that Mr. Kearns gets a copy, I get a copy. You can do that by forwarding it to me directly to my county email, or just attaching that as an attachment, just making sure that you've copied the rest of the parties. And I can get it that way. Because that's part of the challenge. I don't get a lot of your pleadings and other things that I just need to be made aware of, just so I can kind of track them. All right, okay? All right.
Sorry. Hippo Press 365 content 100. Is there a specific case law that backs the loophole? They cited a few cases, which I believe is irrelevant because there are Supreme Court of the United States decision. There are 9 of the circuit courts have made the same decision. The Georgia Supreme Court has made a relevant decision, and there are state cases that says if you make yourself a witness, an unsworn witness, you should be excluded. And that goes for both defense attorneys and prosecutors. But the judge relied on different cases to ignore it. Then there are also a bar code, which means the state bar who controls the ethics of the lawyers. They have rules against this. And there is, on top of that, there is a general rule of professional conduct for a lawyer. So he ignored all of that and relied on a few state cases to make an hearsay exception for employees of Miss Love to testify about conversations Miss Love had with Miss Bennett. Because he's a spineless coward who refuses to make decisions that really goes against the prosecution.
Okay, I've had an opportunity to read and consider the motions filed by Mr. Kendrick. That is the motion to limit witnesses due to undue delay, waste of time, and or needless presentation of cumulative evidence filed on the 19th of March of this year.
Yeah, this is a defense motion regarding the vast amount of witnesses the states are planning to call. And at the start of this trial, it was 771. A month and a half in, the judge reduced that to 400, or the judge told the prosecution, remove all needless witnesses, and they came down to 400. For the first 3.5 months of trial, they have called 40 out of these 400 witnesses. In the month of March, they called a grand total of 3 witnesses. So now the defense filed a motion to get the prosecution any cumulative, any overburden, they have to remove it. And the judge is kind of upset because this trial should have lasted in total. State's case in chief, defense case in chief, state's rebuttal, a grand total of 6 months. That's not going to happen because, in my opinion, the prosecution lied to the judge about how long this would take. They knew perfectly well this would take longer. And by the defense calculations, if this trial, if the prosecution's case keeps at the same pace, this trial will not be done before 2027 at this current rate. So the judge, he finally tries to do something about it. And that is what we are going through now.
Also, amended motion to limit the witnesses due to delay, waste of time, and or needless presentation of cumulative evidence. And that was filed on the 22nd of March. And then I've also had an opportunity to take a look at the state's response to defendant Demontre Kendrick's motion to limit witnesses filed on the 1st of April of this year. Counsels, I've had an opportunity to read your motions, and I really don't need any oral argument on it. I'm going to go ahead and give you my thoughts, okay? And then we can talk any further if necessary. Let me start out first by a brief procedural history of where we are and where the court thinks we are, which you can correct as need be. This case was indicted, or we had arraignments May of 2022. The court then started having proceedings over the summer of 2022. We started motions on or about the 20th of December of 2022. We summoned jurors for January of 2023. We selected a jury on or about 15 November of 2023.
Yeah, it took this case almost 11 months to even summon a jury. And during that time, the prosecution, when they said to the judge, we are ready for trial in November 2022, they had a grand total of 90 witnesses. During the phase of getting a jury seated, that was expanded to 771 witnesses. And the defense said over and over and over again to the judge, this is ridiculous. And when a week before the trial started, the prosecution handed over, they were at around 600 witnesses. 10 days before the trial started, roughly, the prosecution handed over a new witness list, an extra witness list of 150 witnesses, 10 days before trial, and the judge allowed it. Now he tries to go back on that. Here's the thing, Your Honor. You could have done something about this for over a year, and you didn't give two shits on a straw about it. And now you try to blame the prosecution and the defense for all the delays. No, Your Honor. The one person sole responsible for all the delays in this trial is you, because you allow this to happen. And now you try to pull back on it. No. This is your fault, Your Honor. Yours entirely. Because you're a spineless coward.
And started the presentation of evidence soon thereafter. And up to this point in time of April the 2nd, I should say, of 2024, we have summoned some 40-something witnesses at this point, in terms of just a rough framework of what has gone on in this particular case. Now, in reading your...
Another good question from Hippo Press. If a trial court judge enters an order denying a motion for the judge's recusal or for determination of constitutional incompetence, can the trial court's ruling be appealed? Yes, that is a part of the appeal after a potential verdict. It can be a writ, but the judge has to what's it called? The judge has to approve of that appeal during trial. I'm not entirely sure about the Georgia rules here. So take my opinions with a grain of salt.
Issues, Mr. Weinstein, as well as Ms. Love, in terms of the delay. I'm going to group them in two separate, because I don't want you all pointing fingers at one another, and there's enough blame to go around to everybody, all right? But there seems to be two issues and two categories that issues kind of get presented. And the first one is, even though the state has released tranches of discovery over the course of the past year.
Oh, this is a good one. Michael Burke, he's the prime example of the Peter principle. He has risen to the level of incompetence. That's a good statement. For you who don't know about Peter's principle, that is a saying about in every hierarchic organization, you will sooner or later reach your level of incompetence. As in, if you start at the bottom, you do a good job, you get promoted. You do a good job there, you get promoted. You do a good job there, you get promoted. If you stop being promoted, that means you have reached your level of incompetence, since you don't do a good enough work to get another promotion. That's the principle.
Some of it is untimely, and it causes, this is information evidence that the defense claims that they haven't seen or has been.
It is not untimely, Your Honor, because every time they try to bring stuff up in preparation for stuff that might come later, you tell the defense, we will handle it when it becomes an issue. And when it becomes an issue, you're whining like a little bitch about, oh, it's untimely, you should have brought this up sooner, because you're incompetent.
Augmented or has been, they just didn't get it. And a big example was last week when we had the testimony of Ms. Bennett. And even though there were interviews and or text messages that were available, they were not disclosed until the witness was on the stand. Now, the court understands the ebb and flow of trial and understands.
Over at Rumble, Slidey Pie asked, how are they going to keep the jurors that long? I have no idea. They are 3 jurors down. So they have a grand total of 12 plus, at the beginning, they were 12 plus 6. Now they are 12 plus 3 after 3.5 months. The prosecution says that they will take 4.5 months additional for their case in chief alone, depending on cross-examination and rebuttal and stuff like that. Depends on that. And it also depends on half days, administrative days, week off here and week off there. I assume the state's case will still be ongoing when I get to the United States in August. And for you who don't know, yeah, I am coming to the United States in August. I will be traveling on the 6th of August. I will be in Houston for the Matsuri Convention. On the 12th, I start my road trip. I will travel south through Baton Rouge, New Orleans, and then take north to Atlanta. I will be in Atlanta around 14th or 15th of August. I will try to get access into the trial. I will try. And then I will keep going north to Delphi, Indiana, and then up to Michigan to visit Dave over at Making Law Simple Network, and he will take me sailing. And also I will try to take a day trip to Wisconsin to visit Kenosha for the Zachariah Anderson case. And then on the 22nd or 23rd, I will be traveling back. Yay! So now you know that. I will stream and do videos along the way so you all can follow me along on the trip.
That sometimes things happen. And in taking a look at the appellate case law that we've talked about earlier in regards to exclusion, and this is not the first time the court's been asked to exclude evidence by the defense or made such arguments. Mr. Steele has made these arguments before. Mr. Weinstein has made these arguments before, and several of you have made these arguments before in terms of just of non-disclosure and that they should be excluded. But that's just one example of where the state could have and should have provided those particular statements earlier.
Here's the thing, Your Honor. Now you say they could have and should have, but you have consistently ruled against that, allowing the state to be late with discovery, be late with witness list, be late with, even last week, Your Honor, they wanted, the prosecution wanted to have 5 recordings played. They had only disclosed the names of 2 of them to the defense. They had it, but there are thousands of recordings in this case. And the 3 they had renamed. It wasn't the same name in their list as in the list they had provided to the defense. And you still allowed it, and you blamed it on the defense. So this, again, this is your fault, Your Honor, for not acting as a damn judge. You could have done everything about this for over a year, and you have done nothing. And you still managed to blame the defense for it.
And text messages. And what this does is, when we have a jury seat in the box where Sergeant Ingram is right now, and I say, is there anything else that we need to take up? I'm really just kind of being polite. I really am. I really don't expect you all to have anything other than maybe something that's ministerial in nature. We seem to be taking up more and more substantive issues when I ask that question. And it's my pattern and practice to ask that because I don't want there to be anything that's a surprise that we certainly shouldn't have taken up earlier. So it causes great delay. And that is something that the court has indicated all counsel that is a challenge and a problem, and doesn't make your case in the best light it could. So that's why I would rather not call or have jurors present if you all have substantive things to take up that I'm made aware of. And you probably heard me say before, forewarned judge, a happy judge. So, I mean, it's true, because then I can kind of take up things and I can kind of tell the jury, consistent with your ability to try this case without delay and interruption, and put you all in the best light possible in front of this jury. So that's one set of.
You know what would be really good to put a good light in front of the jury? You not calling the defense incompetent, unprofessional in front of the jury, and then not apologize for it in front of the jury. You won't allow the prosecution to call the defense incompetent, unprofessional in front of the jury, and then refuse to acknowledge, or whatever the word is, the state in front of the jury. That would be a good thing for you to remedy. But I know you won't, because you're a coward. I don't care. You spend time in Afghanistan. There's a whole lot of people who spend time in the army, in the Marine, who don't develop spineless coward syndrome afterwards. But there are those who do, and you are one of them, Judge Glanville.
Examples of is the disclosure or non-disclosure, or the alleged non-disclosure, okay? So, and I've had to excuse our jurors sometimes for hours in respect to try and unravel issues that you all presented before the court, which you needed to, but we could have taken this stuff up much earlier and resolved that without our jury being present or our jury being in the box, okay? The second category of issues that both sides argue, or then the court has seen presented in this case, is the defense claims that the state didn't disclose or give evidence which was not disclosed in discovery. So,
And not only that, Your Honor,
we've had to
they can't prepare because you always give the prosecution very slim time margins to abide by. As in, if they are calling certain witnesses, up until now, if they are going to call certain witnesses, say from April 8th to last of April, they don't have to disclose anything until more or less Friday before, giving them more or less no time to prepare. And you have done that for months now.
some of this may or may not have been disclosed in discovery or not. And I find that I have to kind of then unravel that particular issue. Sometimes we sit here in front of a jury and not in front of a jury, but while the jury is in their headquarters, and we have to unwind that. And there are a number of times that both of you, but the defense, I'm going to pick on you, Mr. Weinstein, you filed a valid set of motions and an amended motion, but this morning I got 15 amendments to it. Now, the people from the Catholic school did teach me how to read, but I can't read that fast. Okay, so, but you filed some 15 addendums and everything else that you wanted me to.
Yeah, because you can't make a ruling if your life depended on it, and then you wait to the absolute last minute. They have to amend because of the prosecution and because of you. Because you allow the prosecution to do anything they want. So they have to amend. And now you're blaming the defense for your failures.
Look at. No. Let me finish. The challenge is that if you package them and give them to me earlier, then I'll be, like I said, I'll be a much happier person. The more you can give me, the more ahead of time. I'm very much appreciative. I'll read anything you want me to read, but the sooner you can get it to me, the better off I'll be. But the point being is that I cannot take up your issues while we have jurors waiting to come out. And that seems to be the biggest.
Yes, you have to, if that arises. The defense attorneys has a constitutional obligation to zealously advocate for their clients. There's no right in the Constitution for the prosecution to act with misconduct. There's no right, there's no fair trial right for the prosecution. It's for the defendants.
Argument that we have between both of you. And I told you that this is something that certainly bothers the court, because we have been here this amount of time. Now, related, Ms. Love, I asked you have you gotten the list of potential witnesses and the days you think you're gonna take to present the rest of your case in chief? Just ballpark.
Your Honor, I don't have that for the court, but I can have,
Okay, all right. I told you to have it today. Okay, and this is one of those things that I tell you all. I mean,
See, and prosecution unprepared. They knew exactly what motions that were handled this day, and they still don't give a rat's ass two shits on a straw about it. And you still manage to blame the defense.
it's like what I tell you all is not aspirational. There's a reason I ask you for it. And this is exactly what I'm complaining about at this point. You told me you were going to have it because I told you we were going to have, first we're going to have these motions on Monday and Tuesday, but unfortunately I had a funeral I had to go to yesterday. But so you've had at least a week or so for you to pull this.
Yeah, if you want to wind down after this stream, I have a secondary channel where I read Scandinavian stories, sagas, and folklore. And so if you want to wind down after this, I've pinned that link on the top of the chat. And you can just go over there, listen to me read old stories and stuff. Okay. But we are here for this new story that might be folklore in the future about incompetent judge who allows moron prosecutors to get away with things.
This together and for you to kind of, because I wanted to know how many more witnesses and how many more days. And I told you ballpark and the evidence that you and Miss Hilton and your team is kind of putting together, but that's not ready, is it?
Your Honor, what we have been factoring in was the, it will not be in court. So we have got.
I just asked,
The brief answer is that is not ready at this
how
time.
how many days more of trial do you think that your case in chief will take?
I could-
30, 40, 50, 60? Tell me how many more days you think you're going to have. I asked you to come up with that number because that's.
I believe that, hold on, I'll give the number of days.
All right, just sit there and think about it. I'm gonna come back to you in just a second, okay? But this is a challenge because it's been brought to the court's, allegation that I'd like to, while you all need to try this case and it needs to be fairly tried as to both sides,
No,
we have jurors that,
No, Judge. Not both sides. The right to a fair trial is the defendant's, not the prosecution. There's nowhere a constitutional right to a fair trial for the prosecution. They are supposed to be the guardians of the fair trial. And you are the judge who keeps them in line when they do bad stuff. The defendants have the right to a fair trial, not the prosecution.
we need to present this case in a more expeditious and streamlined fashion. And this is just part of, when I ask you to do something, please do it timely. And this is a problem. We're going to come back to this, all right? So that's part of the challenge in this case. We started out with some 700 witnesses. We came down to 400. State says, well, we got about 200 and thereabouts. And that's kind of what I was going to inquire about today. So I'm going to come back to that in just a second. But I've also, to let you all kind of handle your business, I provided you several administrative days, which I've invited and directed counsel to iron out any preliminary issues that the court may have to take up beforehand, and file suitable motions so that you all can have this before me. And then I can kind of, okay, we got to take up 2 or 3, we've heard these phone calls. There are some issues that kind of came out with that.
No, it is good that the judge finally takes a bit of charge on this. But it's too late. We are 3.5 months into a complete cluster F of a trial. And now you decide to limit or try to skim down something you should have done months ago. Months. I remind you all, when the prosecution told this judge they were ready for trial, they had 90 witnesses for an estimate of a grand total of 6-month trial. We will be here, I can guarantee you, almost guarantee you, we will be here for the rest of the year, even with these limitations.
It's going to take a day. Then I don't bring this jurors back yet for another day, or we plan on it, and then we can take up that. So that has been a challenge, and it's caused a lot of start and stops with our case. So, in looking at 24-4-403, Mr. Weinstein, I don't believe that it does comport to your, even though you and Mr. Abt have artfully kind of fashioned that motion, 403 has to be specifically applied to a particularized situation. It's not that I don't take it, and it has to be taken up on an individual basis. I understand globally what you're asking me to do, and I understand the frustration, but I'm not gonna apply that to it quite yet. However, I am going to apply 24-6-611 because that gives me broad authority.
Hey, Alabama Rose. Hey, I haven't seen you in a good
Exercise.
while. Thank you for being here. I all doing a flyby to say hi. Sub to Nick's Scandinavian Tales channel because of my ancestors and I love stories. Have y'all go sub to that? Yeah, please do. When I reach 500 subscribers on that channel, I will do live readings of old Scandinavian stories and sagas and stuff. At the moment, I pre-record to get videos out because I need to fit in the time for it in the rest of my schedule. 100 millimeters is 1 centimeter. No, 100 millimeters is 10 millimeters is a decimeter. So that's 100 millimeters of rain is a lot of rain. Thank you, John Comyn, for $5 super chats. I only regret that I have but one like to give to N.Starow. Nathan Hales. Okay, thank you so much, John Comyn. And that brings us to $42 more to the next spin of the Wheel of Regrets. $42 more in super chats or gifted memberships gives you another spin of the Wheel of Regrets.
Reasonable control of the presentation of witnesses and evidence to avoid needless consumption of time and other things. So to that event, what I am going to do is I'm going to initiate the following, and I'm going to put it in administrative order. And here's what I'm going to do. On Mondays, Thursdays, and Fridays, we're going to start at 8:45 and reclaim a little bit of time. So if you need to take up anything,
this guy haven't been on time for the entire trial. And now 8:45. Okay, so that means a start at 9:30. I mean, 8:45 is, yeah. It's good that he wants to have longer days. Here's the thing. I haven't seen, I mean, if he keeps doing half an hour, 10-minute breaks, 90 minutes, 1 hour lunches, and late starts, early finishes, half days, of course it's going to take time.
Go ahead and take it up for a jury gets here. That's number one. There's 5 things I'm going to implement. 2 is going to be the exclusion of any evidence, documents, or pictures that aren't timely disclosed. So, defense, if you argue that they haven't been timely.
Here's the thing. You have allowed the prosecution to enter new evidence and new witnesses throughout this trial. This is too late because they already got a lot of stuff admitted that should have been excluded throughout this trial. Good, but damn too late.
Disclosed, it will be the state will have to tell me what date and did you disclose that particular evidence or discovery in the same or substantial format that it was given to the defense. So, because what I'm having is I'm getting, well, the state changes it or expands it or just comes into possession of it. So if it hadn't been disclosed already, you tell me, for example, we gave that to the defense on April the 15th of 2023. And you can show me that it has been in fact filed that day, then we'll proceed. If not, I have remedies. The remedy, I'll exclude it, or I'm going to excuse the jurors on the spot, and they're going to come back the next day, and we're going to work to resolve that. But I'm not going to have them sitting here every day, and then they're going to, of course, make certain judgments for themselves. I'm not going to say anything, but I told you that the biggest thing that jurors complain about is having us to sit back there. Also,
yeah,
if it's
not the first time the judge promises to do anything and then goes back on it.
So number 2 is I'm going to start excluding stuff that if it's changed from discovery, hasn't been disclosed in discovery, or I'm going to reserve the right to go ahead and exercise that remedy at that point in time. So defense, if you're going to make that argument, you need to be able to tell me what's changed about the particular evidence. If so, because after the state tells me, okay, well, we gave it to you on the 23rd, well, then you have to be able to tell me, here's what else they gave me. So I may just exclude that portion of it. So I'm going to start just excluding stuff in that respect because it's not timely. But whoever the proponent of the evidence or asked for the exclusion is going to have to tell me, well, when did you disclose it, and in what form did you disclose it? So because this is why I've told you all get together earlier, talk to one another, and if you have problems, then certainly or issues I need to resolve, file a motion, let me know so I can go ahead and take it up. But I'm hearing about it a lot of times the first time when the jury sits in the box. And I can't do that. It's not fair to them, not fair to me as your trial judge to be able to rule on those kind of things. So related, number 3 is I'm going to start, if appropriate, and I do need to take up something that is of that important or import, I will go ahead and excuse our jurors. and just we'll take whatever, and we'll come back the next day. So that's 3. Number 4 is I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way.
This isn't bad in general. If it was both parties' fault that things took a lot of time, but this is solely on the prosecution and on you for not keeping your courtroom under check, Your Honor. This is on you. Is it good that you try to remedy it? Yeah, but it's too late. It's already in place. You already allowed evidence in that came to the prosecution's knowledge during trial. Ugh.
Too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I'd like to have it. I'd like to go watch the Super Bowl without having to come back to try your case. I hope that your case is resolved by that time, whatever may happen. But I think that we can do a better job at presenting the evidence and streamlining whatever for the fact finder to be able to make a decision. So we're going to start gathering on Saturday and Sunday. And the last remedy, and I don't say this being otherwise mean and contrary and everything else, but I have power of contempt. I don't want to use that. I don't. But it's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case.
Then stop doing the prosecution's job. Stop making excuses for the prosecution. Stop allowing the prosecution to get away with, for out of the blue, ignoring Georgia Supreme Court decisions and allowing the prosecutor to be an unsworn witness. How about that? How about not allowing hearsay testimony to protect the prosecutor? How about that, Your Honor? How about that?
I try the best case you have. So that's why I said I wasn't going to kind of let you all start pointing fingers at each other, because I think there's enough blame to go around. But you all are going to have to, as I said before, do better.
It's your fault.
You all are very seasoned
You allow
advocates.
this to happen.
So I shouldn't be having these many discussions, interruptions. I mean, and I'm in no way saying you're not doing your jobs, because that's what you paid to do. You are doing your jobs. But the challenge to the court is that we've had a lot of interruptions with the jury sitting in the box. And I told you my concerns about that. So that's where I'm going to draw a line. And I've thought long and hard after these motions. I was thinking about this prior to Mr. Weinstein filing his motions and his supplemental motions to limit the witnesses. But I have to do something that will at least make us or force us to go ahead and make sure that we can present a case to the jury that is more streamlined and not stops and starts. I mean, if we get 2 or 3 hours a day, we're doing good, because we had so much interruption. And a lot of that interruption was needless. It could have been taken up much earlier. So that's where I am at this point in time. Now, back to my original ask, Ms. Love. How many more days do you think that you'll have?
No, Kursan, can the judge be held accountable because of all these grievous errors he is doing, or is he immune? Judges are basically immune to everything. There are extreme cases where a judge can be fired, but they often recuse themselves before that. And if the appellate court says this was egregious and we will reverse it, and we will not to you, that's about it. But rarely a judge is being held accountable for his or her errors.
How many more days and witnesses do you think you'll have?
We think about 150 witnesses, Your Honor. And
150.
Roughly 100 and
100 and, come on,
So roughly 120 days.
That's 4.
So the prosecution has so far called 40 witnesses in 3.5 months. Now they claim they can call 150 more witnesses at roughly the same time. Yeah, I know. Do I believe her? Not for a second. Not for a second.
months?
Yes.
Have you all, now is this 120 days of actual like
We were trying.
5 days a week or what?
Right, we were trying to, this is what we were trying to achieve.
Well, if 120 days is 5 days a week, that's a bit more than 4 months. I say bullshit. Complete bullshit.
This is what we're trying to achieve.
Trying to achieve, yeah.
That's what we were trying to achieve, yes. So we were trying.
I don't know if trial judges are allowed to set a time limit on a state's case. If they are, I would say you have 4 months, calendar months, to present the rest of your case in chief. If you can't get through it all, the rest is dismissed. But I assume they can't do that.
Trying to, with the tearing down and with the previous information I shared with counsel for the defendants, this is what we were trying to achieve with our prior request and information that we relate to the court. But that's not inclusive of the length of time it would take counsel to cross-examine all of our witnesses. We don't.
Here, that does not include cross-examination or rebuttal or arguments of motions. Mrs. K, I think they can. We've seen several trials with time limits. Yeah, but aren't those civil? I think those are civil cases. They can put time limits. Yes, no Kursen. 120-day only direct. Yeah. Yeah. And I assume she is, because she said with all the witnesses they had, it would take 6 months for the entire trial. Now she's claiming a grand total of 8 to 9 months for their case in chief alone, without cross-examination.
Just don't have that. We can't factor that in. We don't have any way of estimating that or factoring that part in.
Are these may call or will call witnesses?
The
The witnesses.
remaining witnesses are the definitely will call. There may be more. These are the ones that we have pared it down to, Judge. We are trying.
No, hip-hop. He is the Chief Justice. He does not have anyone superior.
He's
the Chief Judge.
Depending on how the witnesses change their testimony based on whatever questions are asked during.
2D 144, Kentucky, 1990. A trial court clearly has the power to impose reasonable time limits on the trial of both civil and criminal cases in the exercise of reasonable discretion. Okay, but that's Kentucky. We don't know if it applies in Georgia. That could be state law.
Their examinations, there may be occasions where that number changes, but that's the number that we have provided to counsel for the defendants previously when, prior to this motion being filed, and that is the number that we expect to be able to present our case with.
Okay,
Do I think this judge is any kind of reasonable? No, I do not. I think he's a spineless coward who is too scared to impose actual rules of sanctions against prosecutorial misconduct. Probably because he wants to be re-elected. Now I think there's a long pause while... Oh, no, she talks again.
all right, let me ask the state a question. I know that we've touched this before, but
Thank you, Higgles.
so the purported 150 witnesses comport with the rest of the accounts or overt acts that you attempted to prove in your case in chief?
Yes, this is I think I understand the court's question. This is the number of witnesses. This is the most pared down.
Goes through Fani Willis is employed with the current DA, Adrian Love? No, Adrian Love is assistant district attorney. Fani Willis is her boss. She chose to employ Miss Love as an assistant district attorney. Now, there are reports or speculations that Miss Love, she was a prosecutor under the previous administration. And Miss Willis was asked to not employ Miss Love. She did anyway. So her conduct in the courtroom was known prior to Miss Willis employing her.
This is what we expect that we will be able, we hope to be able to prove everything that we intend to put before this jury in our case in chief with these witnesses. If something goes differently than we anticipate, if
Mrs. Kagan, maybe you can offer your services, Nick. Georgia Rule 5.5 also permits both domestic and foreign lawyers to provide some legal services in Georgia if the services are performed on a temporary basis. Here's the thing. I'm a union rep. I have a law degree. I do not work as a lawyer. So that's the distinction here in Sweden. I have to actively work as a lawyer to call myself a lawyer. Lawyer is a protected title here. So even though I have a law degree and I work with law, I can't call myself a lawyer. So the Rule 5.5 does not apply to me, sadly. Now, I do know that some states have taken into account that you don't have to pass the bar exam anymore. I just have to work with a law firm for a year or two or something like that.
some objection is made, if that is sustained, that requires that we call in an additional witness here or there to prove particular points, then we would supplement that list to that extent, but we don't expect that that would increase our numbers by any great percentage.
Okay.
So this is for the entirety of the rest of what we anticipate presenting to the jury in our case in chief. So it includes the counsel on the indictment. It includes overt acts, intrinsic evidence that we intend to introduce. We have served upon counsels for the defendants all of the acts, intrinsic, overt, that we intend to introduce evidence of. And so there's nothing within those witnesses that is not contained in the information that we have provided in terms of what we intend to prove.
Up a bit.
But this is as pared down as we've gotten it.
Okay, so these are the list of 150 are your the witnesses you will call.
Yes.
Okay, all right. Here's what I want you to do. Pursuant to OCGA 17-16-3, I want you to update your witness list.
Mhm.
You have the ability to call anybody that to supplant or supplement, depending upon what other evidence is adduced or is presented that may require you to impeach or rebut or the like to account for variances in presentation of evidence. So I'll allow you to amend to supplement your witness list, but for good cause. But I want to see the 150. I want to see them in terms of the law enforcement and what they're going to testify to, and lay witnesses and what they're going to testify pursuant to counts, overt acts and/or counts, and any expert witnesses that you're going to call.
Okay, so that I understand, the court isn't asking that we give the strategy to, the court is just saying, generally speaking, this act, this, that,
Yes.
this, the other.
At this
Okay.
point, there's not any.
This is good.
One of your predecessors told me once, said, "I'll give you my entire file because if you can beat me with it, you deserve to win." And I think at this point in time, the caliber of lawyers that you have in this courtroom, there should be no surprises. And I'm of the opinion that more disclosure just fosters.
Hip Hop Press, have I noticed any changes in this judge since Steele asked him to recuse himself from the case? Well, he hasn't had the time yet to yell at the defense in front of the jury. So I'll wait for my judgment a few weeks. I will wait for a few weeks before I can claim that he has changed his ways.
There's
I understand.
openness in the proceedings and with what's being presented. So at this point, it's not like anybody's going to be surprised with anything you come up with. At least you shouldn't. There shouldn't be. But I think that in order for us to keep this thing going smoothly or as smooth as possible, the less interruptions that the court has, the better off we'll be in terms of evidence and presentation in front of this jury. So I want that by tomorrow morning, because what I'm going to do is I'm going to take a look at my calendar and we're going to kind of block it. I'm going to see whether or not we are going to meet 4 months or not.
That does not include the length of time.
Well, you can come on the weekend, Mr. Matthews. So don't worry about that. Okay, you let me take care of that. But okay, but that's part of the calculus.
I was going to say that does not include the length of time that.
Sure, I know that. I know that. But what it does is it kind of puts us on a path. At least I'll know, and your colleagues will know, hey, where we are in terms of, so I can start to plug and play and see if we're behind. Because we're behind, I'm gonna make you come during the weekends.
Okay.
I mean, I'm just gonna start doing that because we need to kind of press a little bit harder, or else, as Mr. Weinstein have said, we'll be here in 2027, and that's not what I want for this jury. We need to put this case to them in a fashion that is fair and reasonable, but.
That is very telling. We need to put the case to them. Depending on prosecutorial misconduct, depending on if you actually have enough jurors. And I would argue if more jurors fall off, the defense should put a motion, because the length of this trial was 6 months in total. The only reason why it will be longer, and we heard it here, we can do the next 150 in 120 days, which 120 trial days. That doesn't include cross-examination. So in my opinion, when the prosecution last year agreed to the 6 month, that it would take no longer, you should have held them to that. Now they are claiming more or less that the entire case in chief will take longer, even with the shorter list they had a year ago or 6 months ago. They lied to you, Your Honor, and you're letting them get away with it.
I think at this point in time, Ms. Love and all defense counsels, I think if you iron out and we don't have these hiccups where you all are like, where the state says, well, we gave you 3 things in discovery and now we have 5. And the defense says, well, I need to take up these other 2, which we haven't been given, or we got them this morning, or we got them a couple of days ago, and I haven't had the opportunity to do that. And you want to go ahead and present them. So that's why I'm saying, if you all talk with one another, I mean, you might be able to, I know that you want to present the cases linear as you can in front of the jury, but sometimes that may not be we might not be able to do that because of what comes up. So I'm going to help focus you all a little bit better.
Your Honor, with respect to the second point that the court will be implementing in order to facilitate the presentation of the information to the jury.
That's exclusion?
Yes, of any documents not timely disclosed. So when we stand up, Your Honor, to present or to show something to the witness, it will not include anything that has not been served. But what we are doing is showing to counsel for the defense the numbered exhibits.
Here's what I don't want to hear. Here's what I don't want to hear. Ms. Hilton, a couple days ago, we just found this last night on the person's Instagram.
Your Honor, so
Okay, that's what, and then,
it was just posted. It had just recently been posted.
well, then you should have grabbed that, and whatever time that it was given to you, if it was 6 o'clock in the morning, should have been forwarded over to them so they can kind of say, look, this just got posted, whatever else. Then that's kind of everybody knows. Everybody knows you're probably going to introduce that evidence, and then they can talk with their client, whoever else that posted it, and they can kind of say, well, they can have meaningful discussions, but it shouldn't be done right while our witness is on the stand. That's just another example.
Yes, Your Honor.
Okay, I mean, that's what I'm saying to you. I mean, in terms of if you get something, it needs to be disclosed immediately. And
Then why didn't you do that on day one of the trial, Your Honor? Why have you allowed this clusterfuck to continue without this? Because disclosure and discovery are kind of important. You should have applied this from day one and put a hard, okay, trial started, boom, no more discovery, no more introduction. And even if he's very strong in his words now, I don't trust him. He will, in my opinion, he will continue being a spineless coward who allows the prosecution to do whatever they want.
then you need to kind of let the court know first thing in the morning or as early as you can, saying, we're going to have to take this issue up. What I'm finding a lot of times is the witness is on the stand or the jury's in the box, and we're having to take up that. And we're doing that more often than we are the exclusion rather than the rule. So that's what I mean.
Your Honor, and will the court also just mandate that we provide to each side our numbered exhibits prior to even approaching the witness with them so that we have them? Because
It would be helpful because if you already disclose those in discovery, but what I'm finding is happening is your colleagues say, nope, we haven't gotten that. But you should be able to tell me, Judge, we gave it to him on June the 15th, and it was in this particular disclosure, and this is where it was.
Yes,
Because that's part of their challenge. I mean, they're like, we got 8 terabytes worth of stuff.
we have been providing to them the exhibits we intend to introduce. We're just asking that that be required of both sides so that, for instance, before.
No. Ms. Love, you unethical piece of garbage. You are supposed to disclose this to the defense. For instance, just last week or 2 weeks ago, you wanted 5 recordings entered into evidence. 2 of them had the same name in your as you were presenting them in court, and 3 you have renamed from the discovery. So they were sitting there wondering, we haven't gotten this. And then they try to explain, oh, it's this piece of evidence. And okay, we have them, but they are called something else in discovery. You unethical fuckers rename evidence in an attempt to surprise the defense. And the judge allowed it because he's a spineless coward.
Mr. Kokomo or someone else approaches the witness with
I will make that as part of the defense if they wish to go ahead, and as long as it falls within the rules of the rules that remember
that we
they're not in their case in chief yet,
No.
and they don't have to do anything. So part of the rules don't necessarily apply to them the way they apply to the state at this time. And I know that's frustrating, but that's just part of it. But to the extent that any defendant's going to use any evidence that I'm going to need to rule upon, I do need as much notice as I possibly can.
And Your Honor, what I'm specifically speaking of are physical exhibits that are numbered. There may be on a PowerPoint 25 pictures, and we can't even pose or make an objection or say we don't have any if we don't know what exhibits we're looking at. So we're just asking the court required that we be given a physical copy.
But a lot of times this is evidence that you've already given them.
It is. And so if they're giving it to the witness, we don't know if it's defense 1, 2, 3, so that we can know what it is.
The defense evidence is your discovery, Ms. Love. You gave it to them. You should know this. You have it in your possession because you handed it over to the defense. Now, if the defense chooses to get something completely new, then there's a motion hearing and stuff like that.
Is we're objecting to or not objecting to, so that it's not just on a computer. If we have a physical copy of it, like we provide to them, labeled already, then we can make a more expeditious announcement to the court.
No. The defense, I mean, this is borderlining on what do you call it? Whatever. So I will remember the word for it later.
To the extent that the defense has any materials, it would be helpful for you to show those to the state prior to your presentation, so we don't have delay, to the extent that you can. So I'll make that part of my order, but it's really going to depend upon.
And I don't mean far in advance. I mean prior to saying we're approaching with some pictures, so that we can at least know what it is that we're talking about, like defense 1 through 12. If we just have them, a copy of them, that would be great.
Well, I'll say this: as long as if it involves anything that wasn't disclosed in discovery, because you all should have those. I mean, Ms. Love, I think part of it is
this is the prosecution trying to blame the defense.
That arguably they got discovered. So that shouldn't take that much. That should not take much looking at, or nor should be a surprise to you. However, if it's something that's not been provided in discovery that they wish to go ahead and examine, I would say that probably needs to be disclosed consistent with reciprocal discovery rules.
Yes, Your Honor, and I do not mean.
Yeah, exactly. So far, it's the state's case in chief. You can't apply rules and regulations on the defense that isn't already there because it's not their case in chief yet.
Disclose it to us. I mean, no matter what it is, just so that it's labeled, so that we can.
No matter what it is, no. The defense has no obligations to help the prosecution to alter their case until everything on the defense case in chief starts on the day of their case in chief. Then this is evidence we want included, Your Honor. Here you are. Not a minute before, not a second before, because this is the state's case in chief. There's no obligation for the defense to disclose everything and all. There are specific rules. For instance, in the Delphi case, you want a Franks hearing, you want this hearing, and that is mostly to get the prosecution to hand over evidence you have discovered exists that the state have hidden from you. Yes, thank you, he goes. I'm thinking of Brady violation. Yeah, thank you. I love my chat. When I don't find the words, here you are. You're so good at this. Thank you so much.
Properly speak to it on the record. If they know that they are introducing 12 pictures that the state has provided in discovery, and they are calling them defendants 29 through whatever, if they would simply say, okay, here are the pictures so that we can speak to them even when we get up to read a red. Okay, I'm going to show you what has been marked as defendants 29, 30.
So are you saying it's a labeling issue?
It is. And providing to the state which exhibits comport with which defense number. We have had the circumstance where a computer is taken to a witness and the witness is shown unnumbered photographs, and we have had to.
That is correct. Nathan Wade was only hired for the former president RICO case. And now he's gone. And his soon-to-be ex-wife has filed a contempt of court motion because he hasn't fulfilled his obligations towards her. Isn't that interesting? He was supposed to take care of medical needs for her, and he haven't. It's almost as if Mr. Wade is broke, which is strange because Miss Willis paid him back in cash, didn't she? He should have plenty of money. But it seems like Mr. Wade is completely broke. I might talk about that tomorrow. I have so much to go through. I need more hours of the day.
Stop and say, we need to know what is being shown and how you have labeled them so
I
that we can
understand.
speak to them.
I understand. All right, so both sides can do that. Remember, if you show a witness a document, even if it's for refreshing recollection or whatever, or it's not admitted, it still has to be identified for purpose of record. So I'll ask that all of you do.
That's standard rules. What the prosecution asks is for the defense to disclose this beforehand. And no, they don't. If it's impeachment, then either the state already has it or it will be disclosed during. I mean, they should already have it.
All right. What other issues haven't I dealt with pursuant to your motion, Mr. Weinstein?
Thank you, Your Honor. I just want to get some clarification.
Sure, to the extent
I'm
I
sure
can
the
do.
court understands, but I don't understand. When the state says they have 120 days of direct examination, that's 120 court days, correct? So we're looking at about 6 months more of their case in chief, assuming we ask 0 questions on cross-examination. 120 days, is that 4 months? Or is that, if we're going 4 days a week, for example, are we talking 30 weeks?
We're talking 120 days.
120 court days.
Are you talking about 120 court days?
Yes.
120 court, assuming no, and then we have to add in our cross-examination. So we're here with the state's case in chief through the Super Bowl
That's 6 months.
or more.
Yeah.
Okay.
And Your Honor, that is a
Oh,
it's not precise. And I can do more. It's as precise as I can give to the court at this moment. And Your Honor, I am.
yeah. You just got caught with a hand in the use box. Whatever. 120 court days. That's 6 months. Without cross-examination. That is through Super Bowl, through next year's WrestleMania. I mean, this is so stupid.
I have stated to the court and to counsel for the defendants where it was that we were trying to conclude this case by.
Your Honor, I'm sorry, can I go? Your Honor, courts in the 11th Circuit, the 7th Circuit, the 5th Circuit, the 3rd Circuit, the Western District of Pennsylvania, the Northern District of Iowa, the Eastern District of Kentucky, the District of Mass, and I could probably go on and on if I had more time to research, have used the combined power that you have under 403 and 611 to limit witnesses, limit the number of witnesses, and or put time limits on the state. What I sent you this morning, just to clarify,
there it is, Mrs. K. Grift. There it is. He has the power to put time limits. He has it. I don't think he will, because he's a spineless coward.
should have made it more clear in my email, and that is my fault, was those were not additional arguments or amendments to my arguments. Those were courtesy copies of cases that were cited in the motion or additional cases that I was going to use in my argument. And that was just for the convenience of the state and for the court. So y'all didn't have to pull those up. But they weren't last minute arguments. But Your Honor, and I'll sit down after this because I do believe that you've already made up your mind. But I would just ask the court to reconsider, because I do appreciate that you're trying to grab the bulls by the horns here and make us more efficient. And I don't doubt that those 5 rules that you've put in place will make us more efficient, but we're still trying to be more efficient at something that is going to go on for years. This length of time doesn't include our cross, and it doesn't include our case in chief. So while the state says that I cannot ask for what I asked for under 403, fine. Okay, why don't you put in time limits? It's done over and over again by courts, Your Honor. Because right now, 150 witnesses, 120 court days, just a direct examination. I mean, we're going to be making Super Bowl bets with each other in 2026, Your Honor.
Do you have any Georgia case law that limit the length of witness? I mean, the time of witness testimony, because ordinarily it's a thorough and sifting examination.
Exactly. And so I do not have Georgia case law, but U.S. Supreme Court case law under Getters says that you are not a mere moderator. That if truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. And don't misunderstand me. I understand that you have exerted control. But what I ask is that you listen to what some of these other courts have done. The Reeves case, okay, the Reeves case, Eastern District of Kentucky, it's not controlling. You don't have to do what they say. But I will tell you, it's been cited 69 times throughout the U.S. about how a court needs to get a hold of a case so that you are running the case, Your Honor. You are controlling the court, not either of us, not the state, not the defense. I mean, you read my briefs. You know what they say. I'm not going to repeat it.
But if you leave it up to us, we're going to do everything that we can to put on as many witnesses as we can to hammer home our case. And unless you put some kind of control, as we can see by another 150 witnesses coming out, unless you exert some type of limit, we are never going to get through this. Even working on the weekends, which I really would rather not do. Even working on the weekends, we're not going to get through this case, Your Honor. And let me add something else just briefly, and I know you don't want to hear argument, but I want to mention something that wasn't specifically in there. We are losing our jurors. We are losing our jurors. I look over there at them and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out. In a study from 1987, looking at long trials being more than 20 days and short trials being less than 6 days, in long trials, 46% of the jurors found that evidence was difficult or very difficult as compared to jurors in short trials, 29% in short trials. 7% of them in long trials said that the evidence and testimony was dull, or I'm sorry, very dull, as compared to 0% in short trials. And then here's the thing I'm most concerned about, Your Honor. In long trials, 46% of jurors had their attention wander quite a bit or occasionally, versus 24% in short trials. We are way beyond a long trial. And these studies were done back in the 80s. And when social scientists have been looking at this, in 2004, under a certain measure of attention span done at UC Irvine, the average attention span that you could focus on something, an average person was 2.5 minutes. Now we're down to 47 seconds. So these jurors in the 80s who found that their attention wandered, they're not even close to not wandering anymore. I'm really afraid that what we're going to end up with is a situation where the jurors are making their decision not based on 2 or 3 years of evidence presentation, but on how well the advocates do in their closing arguments.
All right, sir.
Thank you for hearing me out on those additional
You're very
issues.
welcome. You're very welcome. All right.
That is an excellent argument. That should have been brought up before trial. But here's the thing. I think that the prosecution relies on this. Because I wonder what else that study says. Because I wouldn't be surprised at all if you see the longer the trial, the less attention span, the more likely to convict. I wouldn't be surprised at all.
I state with that revised witness list, I do want to see broken out pursuant to count and overt act how many witnesses you do have, because I do want some fidelity in the 150. Okay.
We can do that, Your Honor.
All right. Okay. You want to add anything else, Ms. Love?
Patty B, did the prosecution add another 150 witnesses? No, this is the number of witnesses the prosecution claims they need for their case in chief, for the rest of their case in chief. So they have gone from 771 to 400 to a total 41 witnesses plus 150 to just under 200. But don't bet on it. Don't bet on it. We still have Wednesday to go through. I will speed through this.
No, Your Honor.
Okay. I'm going to have an order. Mr. Kearns, I'll work on an order, administrative order, and I will.
Let's skip through to the next set of arguments.
He's severed. I understand he is a co-indictee in our case. He is obviously not here. He's severed. I understand he's in custody. I believe he's in custody anyway. He was previously arrested and indicted in Cobb County. And that is for an April 26, 2015 alleged shooting at a tour bus that was occupied by a performer, Dwayne Carter, known as Lil Wayne. And he went through with very fine lawyers and he pled guilty. He then appealed with another very fine lawyer, different lawyer, that his guilty plea was coerced by the trial court, and the Honorable Court of Appeals of Georgia disagreed. The Honorable Supreme Court of Georgia agreed with Mr. Winfrey. They vacated and said that the trial judge got involved was coerced the plea. So Mr. Winfrey then eventually pled guilty again. And I believe, I have to check my notes, but it was an Alfred plea, I believe. Anyway, he's now here. So I've always objected that a co-indictee is not testifying that their guilty plea is a confrontation clause. It should not come in at all. But in this particular case, Jeffrey Williams' name is placed in the original indictment, and an indictment is the prosecutor's hearsay. It's blank hearsay. That's according to State versus Brown, which is 298 Georgia, 878, 2016 case I cited in division for paragraph 4. of this motion that I filed on September 15, 2023. So I asked the state, and they're going to alert the court. But, you know, if there's an issue with anybody putting Mr. Winfrey's plea over, it'll be over objection. But if there is, I don't want Jeffrey Williams' name to be in it. He was not charged. He is not pled. He was not arrested. But there was information that the grand jury through the Cobb County DA's office asserted that Jeffrey Williams is an unindicted co-conspirator. So that was my motion.
Okay, all right, state.
Thank you, Judge.
And I will.
Your Honor, I
skip
believe that the
past-
case that Mr. Steele cited for the court has to do solely with the state using an indictment of a non-co-defendant.
Oh, yeah. Blah, 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 blah. Then let's see what the judge says. And then they go on the break.
Mr. Derek Wise, or is that been satisfied already? All right, Mr. Steele, let's take up the motion for notes and recordings for Mr. Derek Wise, or is that been satisfied already?
Oh, I kind of skipped through it. Yeah, they got through that Mr. Williams' name will be excluded from that piece of evidence. I'm just skipping through here.
Your Honor, this was filed on December 15, 2013, and based upon my belief,
2023.
yes,
Okay, all right.
based upon my belief, Mr. Derek Wise has nothing in the discovery. By that, I mean I have no statement from him in any fashion in the discovery. And then on December 13th, pursuant to your order 2023, the Honorable District Attorney Hilton, has always been nothing but professional. She assisted me, and we spoke together with Mr. Wise. And Mr. Wise, according to Ms. Hilton, was supposedly at the barbershop, just so the court knows. And the barbershop is where Donovan Thomas walks out of when he, God forbid, is shot and killed on January 10th, 2015. So Mr. Wise is in that barbershop. Ms. Hilton told me that Mr. Wise spoke with a member of her office, and he was supposedly at that barbershop at the date and time. Ms. Hilton also told me if the state plans on calling Mr. Wise as a
We
witness
might
for trial.
have
That was
half
before
an
the pared down
hour,
witness list.
45 minutes
So this may
left
be, moot if
with the rest
not
of
200
Tuesday
votes, but
and the
I
entirety of
filed it. I was
Wednesday.
told he's going to be a witness. I have nothing at all.
So thank
And
you all for
because
staying
when I
here.
spoke with
Hit
Mr.
the
Wise
like
with Ms.
button
Hilton,
and all of that things. Thank you
on
so
December
much.
13, 2023, Mr. Wise told me, and he was very professional. He said he has nothing to add to this case. He does not know why he's being called as a witness. He has no relevant information whatsoever. Those are my words, but that's what he told me and Ms. Hilton. And if that statement is inconsistent with something that the state is calling him for, then I'd like to know what he said to this state's representative. That's the entirety of the motion.
Your Honor, I can
Okay.
address that with more information. I think
Yes, yes, ma'am.
So there are no statements, there are no reports or statements of Mr. Wise. I spoke with Mr. Wise over the telephone after a member of our office.
Oh, really?
His phone number for me. He said that he was at work at the barbershop at, I believe it's 336 McDaniel Street, which would have been.
Oh, really? You spoke with him on the phone? Another witness you spoke with on the phone, Ms. Love? Another one? Are you going to make yourself a witness in that too? Claiming he said this? Jesus fucking Christ.
One, Mr. Thomas was inside prior to going outside where he was gunned down. That barbershop is listed on the map as A&M Barbershop. It is the one to the immediate right of the barbershop at 330 McDaniel Street where Mr. Thomas failed after being gunned down. Mr. Wise indicated that he heard the gunfire, ran outside after the shooting occurred, and he witnessed Mr. Thomas mumble some words and then take what Mr. Wise believed was Mr. Thomas's last breath. That is the extent of what he shared with me. I believe that he may have spoken of haircuts that other people were getting that Mr. Thomas was paying for.
Then how the flaming fuck is this even remotely?
Did not recall to me, he did not relate to me seeing or being able to identify the shooters. But he did state that he heard gunfire and that he ran outside and he observed Mr. Thomas after he was gunned down. And that he interacted.
Thank you, M. Rob, 91100024. You're my go-to updates for this case. Thank you so much. I'll do my very best.
Okay, to the extent that
give
that's
daily
or in
or
addition to what Mr.
weekly
Steele and
or
Ms. Hilton
several
know,
times a week updates and recaps.
was that anywhere memorialized by any investigative team or any other?
No, this was a
oral conversation that I had with Mr. Wise on speaker, in my office with, one or more of our lieutenants present,
Your investigators.
investigators.
This is so freaking bad.
To that extent, has that been reduced to writing, or is that been made known to Mr. Steele and any of the other councils?
Orally, I think I may have already spoken and indicated as much, but I can send this, this email that I've instructed that says what I just relayed to the court. I can send that to them. But that's the extent of the information that I have to provide to Mr. Wise.
Okay. All right. I'll direct that you send that to councils, and if they have anything that.
This also seems to be something that prosecutions does sometimes. Unrecorded interviews. This is what should have been done. An investigator went to his house or called him into whatever's, record, hi, we just want to ask you these questions, blah, 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 blah. And then you would have a recording. Now you have, oh, my employees listen in on my call. It's infuriatingly bad. And I am suppose they do that because they don't want to have stuff on record.
As a result of that, they can file whatever motions or take up anything they wish to at that point.
Yeah, so it refers it forward.
Yes.
Remember when the judge complained about timely manner? This is him referring it forward. Bring it up when it's time for it. And then he will whine about not in a timely manner. He can't help himself.
You can also, I'll just explain how Mr. Wise came to everyone's attention. Because as Attorney Steele said, there's no mention, at least I know, in the discovery, so I'm just wondering how it fit in.
Born Sinner asks, is there a certain amount of hung jury trials before the case is thrown out? Or can there be like 25 trials with a hung jury and then they still go for 26? It's up to the judge. It's on the judge's discretion how many hung jury trials. Now, I think I heard Jeff, Legal Vices, in one of his streams said the most he have heard of is 5 or 6 retrials before the judge said, okay, this isn't going anywhere. But in this case, 5 or 6 retrials, that's 10, 12 years with them in custody.
I can tell the court, I can put that on record. I called the barbershop that is located at 336 McDaniel Street. I called the other barbershop, looking for who I believe was the owner of the barbershop. And
my verdict of what I've seen and heard so far, not guilty. Not even close.
When was this,
in my
this
opinion.
conversation occur?
But
When
here's
did
the
it occur,
thing.
madam?
We heard everything that is outside of the jury. The jury only hears what happens when they are there. And so far, they have heard the judge scream at the defense at least twice, calling them unprofessional and unprepared. And I don't know, but the jury will decide.
About
maybe December, whenever it was, we provided his name on the witness list. I don't remember the exact date. If his name was on the witness list before December, then it may have been November, it was whenever it was, and right before we put his name on the witness list.
Okay. All right. This is kind of what I mean earlier about it's important to, I mean, I know that the witness has been disclosed, but any statements or anything that you know, would be appropriate to disclose, or at least that we had an interview with him. Here's, you can follow up with it. Talk with him.
No, you haven't
Mr. Wise, you want to talk to him?
anything except your reiteration of this.
Facilitated a communication or conversation between Mr. Steele and Mr. Wise.
This is an unnecessary witness, in my opinion.
Anything else? All right, so Ms. Love's going to construct that email, and if you wish to file anything as a result of that, let me know and do so timely, okay? Anything else? This pertains to Mr. Wise. All right, let's move to the state's motion to bar self-serving and self-quoting hearsay. All right, Ms. Love, is that yours?
Yes, Your Honor.
Okay, all right.
Motion, Your Honor, generally what we have been doing when there is an attempt to introduce self-serving hearsay is that we have been making objections as the instances arise. There were times during opening statements that we believe self-serving hearsay was introduced or was put before the jury. We are aware that attorneys' words are not evidence, but to the extent that any party seeks to introduce self-serving hearsay, Your Honor, we are making a motion in limine to preclude that as the court.
All you have done, I mean, this is in the light of her putting herself in there as an actual witness. And now she tries to ban the defense from certain kinds of testimony. You absolute C-word.
Court is aware that that is not allowed, but we understand that until that time presents itself where it is offered, there's nothing specific for the court to make a ruling on. We don't know what hearsay counsel for either defendant intends to try and elicit from any witness, but we are simply placing counsel for defendants and the court, making the court aware that we do object to self-serving hearsay, and we'll be making objections as those.
Then make those objections at the time. Oh, for fuck's sake.
Instances appear before this honorable court.
All right. Any argument on behalf of any counsel? Mr. Seal, we'll start with you.
No, we'll just follow the rules.
Okay.
To add.
Mr. Weinstein.
Yeah, that's the only reply they needed. We will go by the rules. Because there are already rules in place. This is just the prosecution wanting one motion in all the cluster F they have caused.
No, Your Honor.
Mr. Matthews.
No, Your Honor.
Ms. Westmoreland.
Just ask to say that they identify or can predict self-serving statements or whoever start on it, that they either not particularize motion or at least have a discussion. Show the court real argument and that you're trying to support.
And Your Honor, as we have been instructed by the court repeatedly, since we are not entitled, whatever it is that counsel may want to introduce prior to them, maybe known that they're wanting to introduce it, I cannot read their minds and predict what self-serving hearsay they may intend to try to introduce. We just object to any self-serving hearsay that they may try to introduce.
Yeah, because what the state's trying to say is that, oh, and all you counsel know this accordingly, until it's your case in chief, what you're stating or what you're trying to introduce would be considered to be objectionable. So to the extent that I hear it, I'll rule on it, but that's just what they're asking to preclude. Okay.
Yeah, this is so stupid.
We would object to them introducing words of their clients without the state having the ability to cross-examine them. And that is the whole reason for, of course, the court is aware that privilege.
Yes, ma'am.
Thank you.
Ms. T. Williams? Mr. Sharp? Okay. All right. To the extent that, like I said, you all know the rules,
Yeah.
you know, in terms of
They all know the rules.
24-8-1.
So let's move forward to, let's see here, dun, 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 this part.
See you then.
Oh no, no subtitles. Damn it. Yeah, this one.
All right, Mr. Kendrick and Mr. Weinstein, good morning.
Roll call.
Get to the main matter at hand. I received an email from Ms. Love, 2 emails this morning. First one was regard to.
This is still about their witness list and how they are going to conclude this. So this is the final part. It's half an hour. And now I will put monetization on and see if I remotely survive monetization. This means you might get an ad or two. That will help this channel with $1 or $2. Just so you know. So dun dun dun. Dun dun dun. Monetization on. I will actually show you. Hold on. Boom. There it is. Monetization on. Conservative. This is the lowest amount of ads I can get you. Save. Done. Okay, so you might get an ad or two this final half hour.
This list that we're going to talk about in just a minute, along with an email, which I'll mark as the next court's exhibit in order, which references a YouTube link and maybe used later to in the current examination of Ms. Archellen Bennett. I'll mark that as the next court's exhibit. And then also the next court's exhibit will also be another email that's sent by Ms. Love to all of you at 11:25. That's the last night, I should say. I'm sorry. At 11:25 p.m., which references or summarizes the conversation she had involving Mr. D'Angelo White.
No, Your Honor, it was Mr. Atkins, but it's the same stuff.
Okay. All right. So that's marked as next court's exhibit in order. All right. And then, so to the matter at hand this morning, the state's witness list. So how many witnesses do you have on this current list? And it is enumerated from pages 1 through 12. I'll make that as the next court's exhibit in order for the purposes of our discussions.
Your Honor, inclusive of two names that were erroneously numbered twice, there are 209 persons on that list. There were a few persons who were added as a result of testimony that has come about over the past week.
Remember this from the previous. There's 150 more. Here's the thing. Now she claims 209 in total. Well, they had 41 witnesses. 209, that means 169 more witnesses, not 150, which means an additional 4 weeks of trial on top of what they said yesterday, which means around 7 months, not included cross-examination.
Regarding witness statements made in the presence of investigators and other personnel with the district attorney's office that we have included on here. These are people that we did not. We had no intention initially of calling in our case in chief, with the exception of anyone who's previously been listed on the witness list prior to now. For instance, Chief Investigator Randolph has already testified. We did not intend to call him back, except that the witness has made.
The witness, whom are you referring to in terms of the witness? All right, Mr. Bennett, okay.
She made statements to me. Ms. Bennett made statements in the presence of not only myself, I was never by myself when I spoke with her. So the person.
Yeah, this is what was covered in today's hearing, which we covered at around the 45-minute mark to 2-hour mark, around that time. So you can go back to that, because somehow the state managed, no, the state didn't manage. The judge created his own loophole. It's a, yeah, MROB 9911-0024. It's a crap show. Because she made herself a witness, Ms. Love, an unsworn witness, and the judge allowed her colleagues to testify what they heard, which is hearsay, self-serving hearsay on the prosecution, and the judge allowed it. So that is probably what will happen next week.
Who are listed that are somewhat new. Ms. Dos Reyes, I asked Ms. Bennett about the tall advocate with curly hair that spoke with her when indicated that she did not wish to speak with me outside.
Hey, my monetization is green. Yay!
Lieutenant Baker, Hamilton, Randolph, and victim witness advocate
I wonder
Kelly
how, but I don't complain.
are all persons that
What's Ms. Kelly's first name?
Tamika, Tameka. She's number 63. They are all listed. Those people that I just named are all listed on page 3 of the list that we have provided to your honor and to counsel for the defendants. And they are after crime scene technician Montgomery Porter.
Okay, so the first 56 you have on this list.
MROB 911. If he's not guilty, can he sue the state? No, he can't. If they are acquitted of this, they are let go, and that is reward enough accordingly. It doesn't matter that they have spent years in jail. If they are acquitted, that is considered reward enough.
our witnesses we called already?
Yes.
I know we'll still be examining Ms. Bennett and Mr., I should say, the retired Detective Quinn.
Yes.
So what's your net number of witnesses that you are planning to call?
That are remaining?
That remain, yes, ma'am.
209, 153.
153. Let's see here. They have called 41 witnesses. They claim 209 witnesses, and now they claim they have 153 witnesses left. Now, I'm bad at lawyer math, but that doesn't... No. Yeah. And 153, I don't believe her. I really don't. I really don't. I think they will get new things in.
And
this judge is
this 153 witnesses,
coward.
you still believe and contend it's going to take 120 trial days?
Judge, what we did on our list is we gave a gross estimation based on the length of time that we have had to take with certain witnesses, factoring in both state's direct, anticipated cross, and averaging out the way that certain witnesses such as Mr. Stevens, Ms. Bennett, Mr. Bean have gone in the length of time that they've taken, and applying that, overlaying that analysis over other similar
Listen to the
persons.
bullshit
Our
she's
very,
trying
very,
to
very
apply
rough
here.
estimate.
Can we shut the
Has
door back
the
if you don't mind, please?
I apologize, Your Honor, I didn't.
No, can we shut the door behind you? There's sound is carrying, that's all. Getting your time correctly, you're saying it's going to take us from April the 8th to April the 10th.
Yes, that's
Okay.
exactly how we've listed.
And that's your gross estimate? All right.
Yes.
Okay. All right. Then the next series of witnesses from April 9th through April the 11th,
Yes.
and then so on.
Yes.
Okay. All right.
Now, here is what the judge does. This is good. You have to give thanks where thank is due, or whatever's. And
the longest ones, the court will notice, are 2 homicides that are on the list on our indictment. Those are the acts that we anticipate will take the longest amount of time to.
Okay.
Yeah, the alleged murder accounts, those, and I mean, in the entire month of March, they called 3 witnesses, but the murder charges are the ones they anticipate taking the longest time. And it's so stupid. It's so stupid that they will even, I say it again, I don't think they will be done with their case in chief this year. But, and I'm just going to go through it now because you don't need to hear it. What will happen? The judge told the prosecution they have to apply the evidence they are planning on showing with the witnesses, so that the defense will be prepared, because then they will know what evidence the state seek to introduce, so they can in timely manner make motions and stuff like that. And Miss Love did not like that at all, and I loved it. But that's the judge ruling, and good on him to forcing the state to apply the evidence they plan to the specific witnesses in good time. So there won't be surprise on the day of the testimony. That is the judge ruling on this, and I applaud it. He should have done this from the start, but he didn't. He didn't. So that is what is going to happen coming forward, starting Monday, 8:45, which in reality means 9:30 a.m. I'm interested in seeing this on Monday. The last questions to Ms. Bennett. Now, I don't start when the court starts. I will start 11:30 a.m. That way I can skip through lunch. I mean, I can cover a good few hours. But then I will go back to recaps Wednesday and Friday because there's simply too much downtime in this damn trial for me to cover live every damn day. If it's interesting, I will cover live. Other than that, I will continue to do these recaps. Okay? So now you are all up to speed, somewhat. And yeah, that's about what I have for you today. What I will do now is I will get you over to Broken Baker. He has a new case. So I will redirect you to Broken Baker. And as I always say, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. Thank you all for showing up. I'll see you all here tomorrow again. Bye-bye.